Honourable members, prayers. Almighty God, we humbly beseech thee to look with favor upon this Parliament of the Republic of Ghana. Grant that it may perform its high duty as in their sight. Give divine guidance to the President of the Republic. Endow members of Parliament and ministers of state with discernment and vision, integrity and courage, that through the labors of government, this land and people may be well and truly served, and their good purposes for the common human life be realized in our midst. O God, grant us a vision of our country, fair as it might be, a country of righteousness, where none shall rob his neighbor, a country of plenty, where evil and poverty shall be done away with, a country of brotherhood, where all success shall be founded on service, and honor shall be given to the deserving, a country of peace, where government shall rest on the will of the people and the love for the common good. Bless the effort of those who struggle to make this vision a living reality. Inspire and strengthen our people that they may give time, thought, and sacrifice to speed the day of the coming beauty of Ghana and Africa. Amen. All members, let's turn to page 3 of today's order paper and take item number 5, correction of vote and proceedings and official reports, starting with the vote and proceedings of Wednesday, 15th July 2026, page 1, page 2, page 3, page 4, page 5, page 6, page 7, page 8, page 9, page 10, page 11, page 12, page 13, page 14, page 15, page 16, page 17, page 18, page 19, page 20, page 21, yes, page 21.
Mr. Speaker, thank you for the opportunity. Speaker, page 21, question number 822. Line 2, first word, delete and insert William. And Speaker, if you may, under urgent question, item 10, the wordings, the manner in which they are typed, some of the alphabets are not clear enough. If you could kindly direct that a second look, they take a second look at it, Speaker. Thank you.
Thank you. Table office, take note. Page 22, page 23. Yes.
Speaker, thank you. 22, item 12, statement. First line, we delete majority after deputy and insert minority. The honorable member for Asqua is a deputy minority leader, not majority leader. Thank you for indulging me.
Very well. You are right. Thank you. Table office, take note. Page 23, 24, 25, 26, and 27. All members, the vote and proceedings of Wednesday, 15 July 2026, as corrected, is hereby ordered as the true record of proceedings. Yes.
Right, Honorable Speaker, I believe at conclave we consulted And we are...
Yes, let me do the official report of Wednesday, 8th July 2026. Honourable members, the official report of 8th July 2026 is for your correction. Any correction? Honourable members, in the absence of any correction, the official report of Wednesday, 8th July 2026 is also adopted as the true record of proceedings. Yes, Majority Leader. Majority Leader, let me crave your indulgence to announce the presence of students in our midst. Students and other association members in our midst. We have Catholic Organization for Social and Religious Advancement, led by Prosper Agbetome, Accra Arch-President. They are from Ayawaso West, Wagon, the number 39. We also have Harrow International Preparatory School, led by Blaise GK. Amenku, a teacher. They are from Okaikwe Central, the number 22. Then we have University of Ghana Public Administration Department, led by Mac Nikwe Ashi, President, and they are from Ayawaso West Wagon, the number 34. Then we have Gospel Church International, led by Minister Isaac Kumi, leader. They are from Domi Kobenya, the number 13. Then we also have Revival International School, led by Achiampong Ata Senior, leader. They are from Swame, the numbered 110. Then we have Precious School Complex, led by Ruben Setoji, leader. They are from Pung Akatamanso, and they numbered 89. Honourable members, on your behalf, I welcome all of them to Parliament of Ghana and urge them to have a fruitful visit. You may kindly resume your seats. Yes, leader.
Mr. Speaker, we agreed in conclave that we'll have, with your indulgence, the Minister for Justice lay papers on behalf of a number of ministers who have papers that have to be laid. So if we can vary the order of business and commence public business and take item number 9.
Yes.
Speaker, we can proceed.
Very well. At commencement of public business, presentation of papers, item number 9. The following papers to be presented. Yes, Majority Leader. Item number 9A by the Minister for Finance.
Yes, so with your indulgence, we will request the Minister for Justice to lay on behalf of the Minister for Finance. If you will indulge us, Mr. Speaker.
Yes.
Mr. Speaker, we don't have a problem with the Attorney General laying the paper. Just know that there is Order 97.3 that we might be able to seek for clarification on this matter.
So, are you reminding him of your right? He is the Attorney General, so he knows your right. Yes. So, item numbered 9A, we are taking I to III. Minister for Justice and Attorney General on behalf of the Minister for Finance.
Credit facility agreements between the governments of the Republic of Ghana, represented by the Ministry of Finance, and the International Development Association of the World Bank Group for an amount of $300 million United States dollars to finance the secondary education transformation for access, relevance, and results for jobs project. Credit facility agreements between the government of the Republic of Ghana, represented by the Ministry of Finance, and the International Development Association of the World Bank Group for an amount of $220 million United States dollars to finance the Harmonizing and Improving Statistics in West Africa project, additional financing. Credit facility agreements between the government of the Republic of Ghana, represented by the Ministry of Finance, and the International Development Association of the World Bank Group for an amount of $500 million United States dollars to finance the Ghana Market Access and Connectivity Project.
Honourable members, the item numbered 9AI, II, and III have all been duly presented, and they are referred to the Finance Committee for consideration and report. Item numbered 9B.
Again, Mr. Speaker, with your indulgence, if the Minister for Justice can lay item number 9B on behalf of the Minister for Roads and Highways.
Very well. Yes.
Yes, Mr. Speaker, he can do so.
Very well. Item numbered 9B. Attorney General and Minister for Justice for Minister for Roads and Highways.
Annual statement by the Audit Committee of the Ministry of Roads and Highways for the year ended 31st December 2025. Annual statement by the Audit Committee of the Ghana Highways Authority for the year ended 31st December 2025.
Honourable members, the item numbered 9B, I, and II have all been duly presented, and they are referred to Committee for Roads and Highways for consideration and reports. Item numbered 9C.
Again, Mr. Speaker, with your indulgence and the agreement of my friends opposite, if we can have the Minister for Justice lay the papers itemized as 9C, IV to XI on behalf of the Minister for Local Government, Chieftaincy, and Religious Affairs. Yes.
It looks as if the numbering is problematic. So, table office, take note. So, item numbered 9C.
Annual statement by the Audit Committee of the Ahafo Southwest District Assembly for the year ended 31st December 2025. Annual statement by the Audit Committee of the Nandom Municipal Assembly for the year ended 31st December 2025. Annual statement by the Audit Committee of the Ketu North Municipal Assembly for the year ended 31st December 2025. Annual statement by the Audit Committee of the Sydney West District Assembly for the year ended 31st December 2025. Annual statement by the Audit Committee of the Offenso Municipal Assembly for the year ended 31st December 2025. Annual statement by the Audit Committee of the Brim South District Assembly for the year ended 31st December 2025. Annual statement by the Audit Committee of the Obuasi East Municipal Assembly for the year ended 31st December 2025. Annual statement by the Audit Committee of the Kintampo South District Assembly for the year ended 31st December 2025.
Honourable members, all the items numbered 9C 1 to 8 have all been duly presented, and they are referred to the Committee on Local Government and Rural Development for consideration and reports. Item numbered 9D.
Same applies to item number 9D.
Yes.
Speaker, there should be no disagreement.
Yes. Attorney General, Minister for Justice, for Minister for Energy and Green Transition.
Annual statement by the Audit Committee of the Tema Oil Refinery for the year ended 31st December 2025. Annual statement by the Audit Committee of the Bost Energies Limited Company for the year ended 31st December 2025. Annual statement by the Audit Committee of the Energy Commission for the year ended 31st December 2025.
Honourable members, the item numbered 9D, I, and III have all been duly presented, and they are referred to a committee on energy for consideration and reports. Item number 9E.
Annual statement by the Audit Committee of the Rights to Information Commission for the year ended 31st December 2025. Annual statement by the Audit Committee of the Office of the Registrar of Companies for the year ended 31st December 2025. Annual statement by the Audit Committee of the Office of the Attorney General and Minister for Justice for the year ended 31st December 2025.
Honourable members, the items numbered 9E, I, and I have all been duly presented, and they are referred to a committee responsible for constitutional and legal affairs for consideration and report. Item numbered 9F by the chairman of the committee. Yes, Honorable Habib.
Mr. Speaker, I think I've discussed with the majority leader. I'll do that on behalf of the chairperson of the committee.
Yes.
Agreed on this.
Very well. Very well. Item numbered 9F.
Report of the Public Accounts Committee on the report of the Auditor General on the public accounts of Ghana, pre-university educational institutions for the financial year ended 31st December 2024. Report of the Public Accounts Committee on the report of the Auditor General on the consolidated statements of foreign exchange receipts and payments of the Bank of Ghana for the year ended 31st December 2024.
Honourable members, the item numbered 9FI and II are duly presented and they are for distribution to honourable members. Item numbered 9G.
Right, Honourable Speaker, with your indulgence and concurrence of colleagues opposite, if I can lay the report on behalf of the chairman of the Lands and Natural Resources Committee.
Yes.
Yeah, Mr. Speaker, there is no disagreement.
Item numbered 9G.
Report of the Committee on Lands and Natural Resources on the annual statements by the Audit Committee of the Forestry Commission for the years 2022 and 2023. Report of the Committee on Lands and Natural Resources on the annual statements by the Audit Committee of the Minerals Commission for the years 2024. Report of the Committee on Lands and Natural Resources on the annual statements by the Audit Committee of the Office of the Administrator of Sioux Lands for the year 2024.
Remember the reports numbered item 9G, I have all been duly presented and they are for distribution to honourable members. Yes, Majority Leader.
Yeah, Mr. Speaker, thank you for indulging us. We discussed in conclave that we will request that we commence the consideration stage of the tribunal's bill, which is captured as item number 27. And so at page 15, we have the Attorney General and Minister of Justice, who is the sponsor of the bill, and the chairperson of the Constitutional, Legal, and Parliamentary Affairs Committee. So we're ready to take the bill with your indulgence.
Yes, before then, we're left with two clauses for the defense. Yeah, three clauses. But the indication from the chairman of the committee is that they have dealt with all those clauses, so we should take them. Have we dealt with those clauses? No, we deferred 6, 20, and 27.
Yes, but inadvertently they omitted.
Yes, we can take it.
Okay.
Yes. So have you resolved the 6?
We have done so.
Have you resolved the 20
Yes, sir.
and then the 27?
All.
So, honorable members, we take it and finish it up, and then we come to the tribunal bill. Yes.
Mr. Speaker, that was not the agreement we had at conclave. Let's stick to our original plan. This one just came up now. So what we can do is to go to consideration stage of the tribunal, and then we can be able, because what the chairman is saying, we haven't even cited it, and neither was it discussed with us. So let's go and start with the tribunal. Then we can come back to it, because they are all at consideration stage anyway. Because
Yes, but you see, these 3 clauses were deferred. And the House asked them to go and work on it and report. And then they have worked on it. They are just bringing the report to us.
But Mr. Speaker, are those amendments being advertised on our order paper?
Yes,
The
it's on
amended.
page 13. Because they are deferred clauses. We actually consider them and defer them.
All right. Mr. Speaker, if the majority leader is indifferent to that, we don't have a problem. We can do those clause 6, and then
Very
we
well.
can come back to it.
National Defense University Ghana Bill 2026 at consideration stage. So, chairman of the committee, is the advertised provisions what the committee has agreed upon after the consultation?
Mr. Speaker, the area of contention is 61A and then 61B. We have resolved these 2 challenges. So
Very
we can
well.
Go ahead. Yeah.
So we'll take it one after the other.
Yes, please.
Clause 6. Yes. So clause 6, we've already read it. So, Chairman, you have the floor. Item numbered 1.
Mr. Speaker, clause 6, amendment proposed. Subclause 1, paragraph D.A. Delete and insert the following. A chairperson nominated by the president. I so move.
It is for the consideration of the House. Honourable members, any further amendment? Honourable members, the essence is to bring it in line with all other university bills that we have passed. Chairperson appointed, chairperson nominated by the president. Yes? Yes, Honourable Shaibu? Honourable members, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Chairman of the committee, item II.
Mr. Speaker, subclause 6, amendment proposed, subclause 1, paragraph F, delete. We are deleting the chief director of the ministry responsible for defense from the membership of the council. I so move.
It is for the consideration of the House. All members, any further amendment? In the absence of any further amendment, I'll put a question. Those in favor say aye. Those in favor say aye. Those against say no. The ayes have it. Clause 6 is ordered to stand part. The proposed amendment to clause 6 is ordered to stand part of the bill. Chairman, proposed amendment III.
Amendment proposed, subclause 1, paragraph G, delete and insert the following as advertised on today's order paper. I so move.
Honourable members, is for the consideration of the House. Any further proposal to amend? Yes.
Mr. Speaker, a further proposed amendment to GIII to qualify who represents the Ghana Tertiary Education Commission. So not below the rank of a director. So just as we have for Ministry responsible for Defense under I, Ministry responsible for Education under II, under GTEC, Ghana Tertiary Education Commission, not below the rank of a director nominated by the Ghana Tertiary Education Commission. I so submit, Mr. Speaker.
Why are you saying so in view of IV?
Speaker, the reason is
and then V as well. You know of their ranking? So probably it means they are just looking for a representative from there.
Speaker, GTEC.
Because if that amendment is carried, and we have to, the fourth one, civilian academic staff of the constituent colleges, nominated by the civilian academic staff of the constituent colleges. This one, they didn't state any rank. I believe these ones, when it is coming to ministries, then they indicate ranks. That's the sense I'm gathering here. And if you look at civilian non-academic staff of the constituent college, nominated by the civilian non-academic staff of the constituent college, they didn't indicate any rank. Yes?
Mr. Speaker, at committee, in fact, when the GTEC was represented, they actually accepted the position taken by my colleague that the rep of the Ghana Tertiary Education Commission should not be below the rank of director. So if you look at our report, that is what is actually captured. So I want to think that the ranking system is well respected within the Ghana Tertiary Education Commission itself, which is why...
Very well. Then I'll put a question on the proposed amendment by the chairman of the committee as further directed. Chairman, are you in agreement?
Mr. Speaker, I have no objection.
Very well. So it's for the consideration of the House. Any further amendment? I'll put a question. Those in favor of the proposed amendment by the chairman of the committee to clause 6, as in item numbered II, as further. Yes.
Thank you, Mr. Speaker. Further amendment to III, clause 6. Mr. Speaker, this is an educational institution, and as such, we cannot have only one student representative on the council. This is an institution that is made up of both graduate and undergraduate students. And as such, just having one student nominated by the SRC is not something that we will advise. If you look at the current renditions and the KNUST bill, which we keep referring to, we have 2 student reps, one by the SRC, which is undergraduate, and one also by the Graduate Students Association. So, by graduate, make it specific because there could be other Graduate Students Associations. So, Mr. Speaker, I propose that we include additional sub-clause for G, where we will have one student rep nominated by the Graduate Students Association. Then, of course, we can also amend 6 VII to include undergraduate students, as is captured in the KNUST.
Yes,
Act.
Chairman of the committee.
Mr. Speaker, we discussed this at length at the committee level. and finally settled on SRC being putting up one person to be on the council. That was the decision at the committee level. But I leave it to you and the House to decide.
Yes, but the VII is even saying students of the university. It's plural form. So he is asking how many? It should be 2 students.
Mr. Speaker, if I listen to him carefully, he's asking that probably a graduate student be added. If
No,
that is what
he's first saying that the students should be 2 representing the SRC. Then the third one is additional clause to make provision for graduate students.
And Mr. Speaker, respectfully, we can go with the provision as is in the KNUST and all the other universities. We have one for the undergraduate by the SRC, then one for the graduate students. So we have 2 reps, and it would be unfair for an educational institution like this to have just one student representative representing students.
Yes, Honorable James Agalga.
Mr. Speaker, I think for once I would support my colleague. For once, yes. Mr. Speaker,
Honourable members, I'll put a question on his proposed amendment to add 2 to VII to mean 2 students of the university nominated by the Student Representative Council. And then, yes. Yes, it's good you are drawing my attention to it. In this case, if you look at the opening phrase, it says 1 representative from all. It says 1 representative, the opening phrase.
Yeah, exactly so, Mr. Speaker. That is why I'm asking if we want
1 representative each of the following.
Yeah. So we can have one, we can amend.
Are you part of the committee?
Yes,
What was agreed upon at the committee meeting?
We discussed this at length, but Mr. Speaker, for the sake of the students, and if we couldn't agree on it, it's good that I come to the plenary to advocate for the student for whom this university is being built.
No, I'm just asking that what have you agreed upon at the committee? You are entitled to depart from the committee's decision. The House wants to know what the committee has agreed upon.
Yeah, so the committee agreed that 1 student nominated by the SRC, but my counter proposal or amendment is that 1, we should amend VII to include undergraduate students.
In that case, I would push for the second amendment that you are making that will make provision for a graduate student. And that would then make it 2.
I agree. So
yes.
So
there will be additional clause.
So I propose
that
an
is VIII. Yeah. Yes. So propose a rendition.
Thank you, Mr. Speaker. So I do propose that additional clause be added to clause 6, the subclause G, to VIII, and to read 1 student of the Graduate Association of the university.
Honourable members, this is for the consideration of the House. I will then put question on the proposed amendment by the chairman of the committee as variously amended. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment by Dr. Chea Samoa and Honorable Shaibu, as well as the chairman of the committee, are all ordered to stand part of the bill. Yes, Chairman, item IV.
Mr. Speaker, amendment proposed. Subclause 1, paragraph I, line 1, delete 4 and insert 3. I so move.
Honourable members, the proposed amendment is for your consideration. Any further amendment? In the absence of any further amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment to clause 6 as in IV is ordered to stand part of the bill. I'll then put a question on entire clause 6 as variously amended. Those in favor say aye. Those against say no. Honourable members, clause 6 as variously amended is ordered to stand part of the bill. Chairman, clause 20. Chairman, clause 20.
Mr. Speaker, clause 20, amendment proposed. Subclause 1, after paragraph C, insert the following new paragraph, deans. I so move.
It is for the consideration of the House. Honourable members, any further amendment? This is simple. I'll put a question. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment to clause 20 is ordered to stand part of the bill. Chairman VI.
Mr. Speaker, amendment proposed. Subclause 1, paragraph E, delete professional and insert professorial. I so move.
I'll put a question. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment to clause 20 is ordered to stand part of the bill. Chairman VII.
Mr. Speaker, amendment proposed. Subclause 1, paragraph H, delete. I so move.
It is for the consideration of the House. Honourable members, any further amendment? In the absence of any further amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment to clause 20 is ordered to stand part of the bill. Now, I'll put a question to entire clause 20. In the absence of any further amendment, those in favor of clause 20 as variously amended, standing part of the bill, say aye. Those against say no. The ayes have it. Clause 20 as variously amended is ordered to stand part of the bill. Clause 27.
Clause 27, Mr. Speaker, yesterday we deferred it.
Yes.
But unfortunately,
so, turn to other paper addendum.
I'm yet to receive a copy.
So use the proposed amendment that we have. Oh.
Mr. Speaker, amendment proposed. Clause 27, paragraph C and D, delete. I so move.
Honourable members, let's take it one after the other. Let's deal with paragraph C. So, honourable members, the proposed amendment is to delete paragraph C of clause 27. It is for the consideration of the House. Any further amendment? In the absence of any further amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Paragraph C of clause 27 is ordered to be deleted. Now, II. Chairman.
Mr. Speaker, amendment proposed, paragraph D, delete. I so move.
Honourable members, the proposal is to delete paragraph D of clause 27. Is there any further amendment? In the absence of any further amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Paragraph D is ordered to be deleted. Now, I'll put a question to entire clause 27. As many as are in favor say aye. Those against say no. The ayes have it. Paragraph 27, as variously amended, is ordered to stand part of the bill. Long title.
An act to establish the National Defense University, Ghana, and to provide for related matters.
Chairman of the committee.
Mr. Speaker, there is no proposed amendment.
It is for the consideration of the House. Honourable members, any proposed amendment to the long title? Honourable members, in the absence of any proposed amendment to the long title, I'll put a question. As many as are in favor of the long title standing part of the bill, say aye. Those against, say no. Honourable members, the ayes have it. And that brings us to the end of the consideration stage of the Defense University Ghana Bill 2026. Yes, but you come back. Our members, we then move to the tribunal bill. So the tribunal bill 2026 is at consideration stage. Honourable members, clause 1.
Application of this act.
Chairman of the committee.
Speaker, clause 1, amendment proposed. Line 2, delete this act and insert the Constitution and this act. I so move, Mr. Speaker.
Honourable members, the proposed amendment is for the consideration of the House. Any further amendment? I'll put a question. Those in favor of the proposed amendment by the chairman of the committee, say aye. Those against, say no. The ayes have it. The proposed amendment to clause 1 of the bill is ordered to stand part of the bill. And I'll put a question on the entire clause 1 in the absence of any further amendment. Those in favor say aye. Those in favor say aye. Those against say no. The ayes have it. Clause 1, as amended, is ordered to stand part of the bill. Clause 2.
Object of this act.
Chairman of the committee.
Speaker, no proposed amendment, please.
It is for the consideration of the House. Honourable members, any proposed amendment? In the absence of any proposed amendment, I'll put a question to clause 2. Those in favor say aye. Those against say no. The ayes have it. Clause 2 is ordered to stand part of the bill.
Guiding principles.
Chairman of the committee.
Speaker, no proposed amendment and the guiding principle.
It is for the consideration of the House. Honourable members, any proposed amendment? In the absence of any proposed amendment, I'll put a question. Those in favor of clause 3 standing part of the bill say aye. Those against say no. The ayes have it. Clause 3 is ordered to stand part of the bill. Clause 4.
Establishment of the tribunal system.
Chairman of the committee.
Speaker, no proposed amendment.
It is for the consideration of the House. Honourable members, any proposed amendment to clause 4? I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 4 is ordered to stand part of the bill. Clause 5.
Administration of tribunals.
Chairman of the committee.
Speaker, clause 5, amendment proposed. Head note, delete tribunals and insert tribunal. I so move, Mr. Speaker.
The proposed amendment is for the consideration of the House. Yes, Honourable Minority Leader.
Speaker, I'm sorry to take you back to clause 4, if you would indulge me.
Well, I'll reverse and indulge you.
I'm grateful. Speaker, with respect, I move that the entire clause 4 be deleted. Mr. Speaker, my reason is very simple, Mr. Speaker. I would take us to Article 125. Mr. Speaker, Clause 4 refers to Clause 2 of Article. It refers to Clause 2 of Article 125 and Clause 1 of Article 126. Mr. Speaker, Clause 2 of Article 125 reads, citizens may exercise popular participation in the administration of justice through the institution of public and customary tribunals and the jury and assessor systems. And if you go to 126, Clause 1, Mr. Speaker, what the provision is saying is that because of the provision of such lower courts or tribunals as Parliament may by law establish. So they are rooting that provision from this. Mr. Speaker, let's go to 142 itself.
Are you talking about Article 142?
Yes, Mr. Speaker, I'm making reference to all the constitutional provisions that have been cited in the clause that I'm seeking to
Very well.
Get deleted. Mr. Speaker, if you go to 142, where the establishment of regional tribunals have been provided for as the Chief Justice may determine. Mr. Speaker, clearly for many years now, we all know that the justice system that we have in this country has worked. However, Mr. Speaker, the disagreement we may have with certain pronouncements of certain judges. Mr. Speaker, like this morning, my Lord Atuguba, all of us were there when he raised concerns about even certain pronouncements of our courts. Mr. Speaker, that does not mean that we create some parallel structures that we call it a justice system. Mr. Speaker,
Honourable members, let's take it one after
provisions in
the
the
other.
Constitution.
So let me indulge him.
The
Yes,
provisions in the
Honourable.
Constitution were qualified. We cannot be interpreting constitutional provisions in a disjointive manner. Then, in so doing, we create chaos in the system. Mr. Speaker, how on earth do we create a new system to compete with a known system just because somewhere in the Constitution certain pronouncements are made? So we should bring an enactment to govern it. Is that what we are doing? A district tribunal, a regional tribunal, to do what? Mr. Speaker, a tribunal to do what? To compete with a high court? Or to compete with a court of appeal? Or there's going to be a Supreme Tribunal Council? Because if you start this way, what you are going to do is now you are now going to have another Supreme Tribunal Council, which is going to now, you tell us that the Constitution talked about it, so that is also equivalent of a Supreme Court. That is what you are trying to do. Mr. Speaker, I do not think that we need this provision. The entire clause 4 be deleted. Mr. Speaker, the entire clause 4 be deleted. What kind of chaos are we setting? Are we introducing? In the name of reset, you have a district court, you have a circuit court, you have a high court, a court of appeal, you have a judiciary architecture that is not broken. Is it the creation of tribunal system?
No.
Mr. Speaker, you want a Chobwe court. That is what you want. Where justice delivery cannot be guaranteed. Populism, Mr. Speaker, we don't need this. We don't need this.
Leader, are we doing second consideration
Mr. Speaker,
or second
I'm
reading?
justifying, Mr. Speaker, I'm not doing that.
Second reading
Mr.
of the
Speaker, I am
bill.
not doing that. Whenever you propose an amendment, you must justify. That's all I'm doing. I cannot bring a lame application before you, knowing Mr. Speaker. Mr. Speaker would want to find out the grounds upon which I mount my application. I am only, Mr. Speaker, I am only mounting my application on solid grounds, and I need to persuade my colleagues. Mr. Speaker, we don't do this at consideration stage. You listen to your colleague. There's nothing like point of order when it comes to consideration stage. There's no point of order. Colleagues must listen. When I finish, you bring your counter argument. This is a persuasive point in our deliberation. I want to carry you along. That,
Okay,
Mr. Speaker, we already have an unbroken...
I want you to carry all of us along.
Very
you
well.
make reference to 126. Look at 126 A, I. What do you make out of it?
Very well. Mr. Speaker, let me read it. Let me read it for you. Mr. Speaker, you said 126 A, I. Which of them specifically, Mr. Speaker?
126 A, I.
All of them. What do I make of all of them?
The I just says that the Superior Court of Judicature comprise the I state, the High Court, and regional tribunals.
Mr. Speaker, what I am saying, yes, so, Mr. Speaker, what I am saying, that the fact that this provision is there must not lead to any interpretation in isolation. Look at the constitutional, the judicial architecture as a whole. Mr. Speaker, look at it as a whole. Why would you need a tribunal? You need a tribunal to do what? Mr. Speaker, I am saying.
Okay,
Speaker,
you also make reference to 142. This consideration stage.
Yes.
Can we look at the 142 together?
Yeah, Mr. Speaker, we are doing so. Yes.
So the 142 says that there shall be established in each region of Ghana such regional tribunal as the Chief Justice may determine. Thus, putting these two provisions together, does the Constitution makes provision for establishment of regional tribunals?
Mr. Speaker, the Constitution is telling Parliament to make a determination. The Constitution says Parliament, as Parliament may determine. Mr. Speaker, and I'm saying that this Parliament must know that the justice architecture we have is not a broken architecture. It's not. It is not a broken one. We have a district court. We have a circuit court. We have a high court. We have a court of appeal and the Supreme Court. All these years, we know that during the transition into democracy, there existed some populist justice system which found its way into the Constitution. Is the reason why the framers of the Constitution indicated that Parliament may legislate.
Minority Leader.
Yes, Mr. Speaker.
Does it mean the framers of the Constitution do not know that we have district courts, we have circuit court, we have high court, we have court of appeal and Supreme Court before stating regional tribunal?
Mr. Speaker, I am making my political argument, and the political argument I am making, interlacing it with the law and governance. Mr. Speaker, we have to test the efficacy of the governance architecture. That is the argument I'm making. And I'm saying that the framers of the Constitution did not impose this on us as a parliament. They have never imposed anything, so nobody should take solace in the Constitution and say that it is in the Constitution. No. They say Parliament may. Because, Mr. Speaker, we have to be careful creating an analogous justice system. We have to be careful. We have to be careful. Because, Mr. Speaker, it leads to some uncertainty. Now you are bringing a whole legislation for this, Mr. Speaker. Instead of improving on the structures and resourcing the courts, help the court to be fully digitalized, help the court to have the necessary tools to administer justice. Then you say you are creating another bureaucracy to bring a new tribunal. Mr. Speaker, we know of what the tribunals did. The dark days of Ghana, we are revisiting it on Ghanaians in this democracy? No. Mr. Speaker, the Attorney General himself is a human rights practitioner. We know his record at the court. A respected human rights activist, a respected human rights lawyer. He is introducing this tribunal system that is going to destroy the justice delivery system. Mr. Speaker, we have to be careful. Is it going to be in charge of civil matters or criminal matters? Mr. Speaker, I am asking rhetorically. Respected Leonard, you must listen to me. You have your opportunity to have a bite. This is unfair. Respected Leonard Attorney General, first gentleman at the bar. This approach is wrong. This is wrong. You have your bite.
Honorable
You have a
Minority
bite in the mic.
Honorable
There's no
Minority
point
Leader,
of order. Mr. Speaker,
Honorable
let him
Minority
sit down.
Leader,
It's wrong.
Honorable Attorney General,
And I'm
please,
your senior in this
both of
chamber.
you should resume your seats.
I'm your senior. I
Honorable,
agree, but I'm your senior
Honorable,
here, and I'm your
please,
senior here.
both of
And
you
I'm your
should
senior here. What
resume
you are
your
introducing
seats.
chaos. That is what the tribunal will do. What you are doing is what the tribunal will do. They should let us speak.
Both of you resume your seats.
The tribunal system. This is the tribunal system. This is the tribunal
Honorable
system.
Minority Leader,
Tribunal
Attorney
system.
General, both of
Populism.
you should resume your
Tribunal
seats.
system of justice. Tribunal system of justice. That's what you are practicing.
Honorable members, the truth must be told. Honorable members, order. Honorable members, the truth must be told. The truth must be told. Please, at the consideration stage of a bill, we don't debate as if we are debating the second reading of a bill. The debate of second reading has been concluded. If you move amendment, I do not think the justification for your amendment should even go beyond 2 minutes. If we were to do a consideration stage as if we are debating the second reading, then I believe strongly we cannot go through a consideration stage of a bill. So we need to be guided by our standing orders. The rule is that you move your amendment, you justified it, and then we put the question and let the House take decision. So please, let's not reduce a consideration stage of a bill to a second reading stage of a bill. With all due respect, let's do the right thing. So, how many minutes more do you need to finish?
Mr. Speaker, This is a subtle attempt to frustrate advocacy on the House floor. Mr. Speaker, this is a serious constitutional matter, and I speak for my side. There cannot be a subtle way that when I'm justifying my application, I'll be told that there's supposed to be 2 minutes, has to be brief. Mr. Speaker, this is a government that is seeking to use a legislation to create an analogous justice system.
Honorable Minority Leader,
Mr.
your
Speaker,
amendment must be for the consideration of the House.
Mr. Speaker, it is so. I need to carry them along with respect, sir. I need to carry them along. So, Mr. Speaker, let me finish my argument. I will finish it in all humility, sir. Mr. Speaker, I contend that creating this new tribunal system by this provision, Mr. Speaker, will bring chaos to the justice delivery system we have in our country. Mr. Speaker, this is populism. We need clarity. Justice must not just be done, must be seen to be done. Mr. Speaker, I remember the famous case of Tagore and Issa Abbas, where the respected Dr. Dominic Ayeni took the matter up at Court of Appeal. These were individuals who were convicted. And at the Court of Appeal, his argument was that a man may not just be convicted because of his own words. That is populism. He argued. He said every element of a crime must be proven. Lead evidence of probative value. That was the argument of the respected Dr. Ayeni. It was because we had a clarity, certainty in the law. We had a Court of Appeal, well properly constituted. Today, you want to have a tribunal? A tribunal. Populism, Choboy justice. Choboy justice. Mr. Speaker, Choboy justice, where people will be sent and people will be thrown into jail. Mr. Speaker, I will not sit here as a minority leader and allow this provision to stand. I move that this provision be deleted. Mr. Speaker, I so move.
Honourable members, the proposed amendment is for the consideration of the House. Now, let me hear the Attorney General and Minister for Justice.
Right Honourable Speaker, I think you brought a lot of clarity to this issue when you drew the attention of the Honourable Minority Leader to the fact that at the consideration stage, we are not supposed to spark debate as if we are at the second reading of the bill. You are to justify each amendment that you have proposed and to persuade all of us to vote in favor of your amendment. Now, Right Honourable Speaker, he has said a lot of misleading things. These things are textually incorrect as far as the Constitution is concerned, because as you yourself drew his attention to the provision in Article 126 of the Constitution and 142, but let's start with 126. It provides an integrated judicial system that includes regional tribunals, and that also includes such lower courts or tribunals as Parliament may by law establish. And Mr. Speaker, this is exactly what we are doing. In terms of the regional tribunals, what we are doing is just simply amplifying the provisions of the Constitution in 126 and 124. In terms of the district tribunal, what we are simply doing is implementing 126 by creating a lower tribunal that will deal with criminal matters that have been specified in the bill, including those of illegal mining. So, Mr. Speaker, we are not creating a parallel justice system. We are simply amplifying what is provided for in the Constitution. Also, I'm happy that he says that it's a political argument that he's making and not a legal argument. You are making a political argument because the argument that he has made, please.
But Honorable Minority Leader, you know that when you get up and you want to speak, you catch the eye of the speaker. So why is this thing happening? I didn't recognize him. I did never recognize him. This is the only occasion that I recognize the Attorney General. This is the only occasion I recognize the Attorney General. You understand? So, I mean, the House must be orderly. The House needs to be orderly. Yes, Honorable Attorney General, you have the floor.
Yes. Right, Honorable Speaker. Let's even admit that it was a political legal argument. It is still at that level very unfounded. It is very unfounded because we are not creating a parallel system of justice. We are not creating a parallel system, a system of justice that will compete with the existing court system. In fact, constitutionally and textually, as I have pointed out, and historically, the tribunal system has been an integral part of our fourth Republican judiciary since 1993. So we are not creating any system of justice that will compete with the existing system, because the existing system, includes the traditional system. The tribunal system. So, Mr. Speaker, I think, Mr. Speaker, I think that the amendment proposed is unfounded and should be rejected by the House. Well, I'm not moving.
Honourable members, I will then put a question on the proposed amendment. Yes.
Mr. Speaker. Oh, okay.
Yes.
Thank you, Right Honourable Speaker. Mr. Speaker, I rise to support the application of the Honourable Minority Leader, Mr. Speaker, that the entire Clause 4 of the bill be deleted from the bill, Mr. Speaker. And indeed, Clause 4 goes to the gravamen of the bill, the establishment of the tribunal system, Mr. Speaker, as this bill seeks to promulgate and establish. Mr. Speaker, I say so because when you look at Article 126 of our national constitution, as has been variously referred to, and which provides for, Mr. Speaker, the establishment of lower courts or tribunals as Parliament may by law established. Mr. Speaker, so legally, the bill is properly grounded. However, Mr. Speaker, laws are to be established within a constitutional and democratic system in a way, Mr. Speaker, that will advance the ends of this constitution, the 1992 constitution, in its totality. And in its totality being, Mr. Speaker, that Ghana, as a democratic and constitutional state, should have a judicial system which is fit for purpose, which indeed, Mr. Speaker, will promote our democratic aspirations as a country, which is why, Mr. Speaker, the Minority Leader has rightly argued that Clause 4 of the bill be deleted. And in fact, Mr. Speaker, I will take it a step further. Mr. Speaker, that the ongoing efforts to review our national constitution should actually consider amending Article 126 to take out Article 126(1)(b) and make it impossible for this House even to consider Clause 4 of this bill in the first place. To mean, Mr. Speaker, that we should not even have a tribunal system at all, which is why Clause 4 should be abolished. And Mr. Speaker, what is the reason? In all democratic societies in the world, and by that I refer with emphasis, well-established democratic systems. Mr. Speaker, the judicial system is well-structured and established. District courts, if you want community courts, you have it. Circuit courts, High Court, Court of Appeal, Supreme Court. If you lose at the Supreme Court, Mr. Speaker, you have a right of review. Mr. Speaker, I'm yet to be told in which established democratic dispensation in the world, whether in the Westminster system or the American system or North American system or our contemporaries in Africa like Kenya, Nigeria or other places where they have a high court and have a regional tribunal and have a chairman of the tribunal and have 2 appointees more or less by the establishment, and that exercises jurisdiction which is almost coterminous to the high court. Let them tell us today, Mr. Speaker. There's none like that. And that is why the minority is making the case that let us examine these clauses in its totality. In its totality, as we are dealing with a constitutional democratic country such as ours has been since 1993 to date. Mr. Speaker, let me conclude by urging on our friends from the majority side and urging on the respected Honorable Attorney General that sometimes, Mr. Speaker, when you sit on the right-hand side of the Speaker and you are arguing for the enactment of laws, you look at it with the greatest of respect, with the greatest of respect, and I say so with a lot of respect, from a narrower view, in terms of you seated on the right-hand side of the Speaker. But you make laws, Mr. Speaker, contemplating when you're on the left-hand side of the Speaker, and the law has been enacted. Mr. Speaker, I shudder to refer this House to the enactment of willfully causing financial loss to the state. We are reliably informed, and Hansard will bear me out, that at the time the law was being enacted, some elements seated on the right-hand side of the Speaker cautioned about the nature of that law. And we all know how this law has been applied in our country. So, Speaker, this country, I want to conclude. We've had a district court, we've had a circuit court, we've had high court, we've had court of appeal, we've had Supreme Court. Our democracy has functioned and functioned well. If it's a question of dealing with backlog of cases, strengthen the judicial system, build more courts, as President Akufo-Addo built more than 100 courts, recruit more staff, recruit more lawyers, strengthen the institution. Do not duplicate institutions. Let us rather strengthen the judicial system as we have it, Mr. Speaker. And therefore, we are inviting our friends to join us to support the minority leader's application for clause 4 of the bill to be deleted, and as I have added, for this whole concept of the tribunal system to be jettisoned, because, Mr. Speaker, if you look at it properly, it is alien to the aspirations of a constitutional and democratic society such as ours, as we practice in this Fourth Republic. The British Westminster system will bear me out, the American system will bear me out, all established democracies will bear me out. Mr. Speaker, we do not want a tribunal system. It shouldn't be an avenue to fast-track justice. Mr. Speaker, one innocent man jailed, Mr. Speaker, is worse than 99 guilty people freed. And it's been said, do not let us have any kangaroo court system in our country. What we have is fit for purpose. It's been so throughout this Fourth Republic. I so submit, and therefore, Mr. Speaker, let's support the minority leader's application to have this clause deleted. Thank you, Mr. Speaker.
Thank you, Mr. Speaker. Mr. Speaker, I rise in support of the proposal by the minority leader that the entire clause 4, establishment of the regional of the tribunal system, be deleted. Mr. Speaker, I say so because listening to the argument in the chamber, it is very clear that the establishment of the tribunal will not address anything new that the existing system cannot address. What is the tribunal coming to address that our district, our magistrate court, our circuit court, our high court, the court of appeal and the Supreme Court, what will they address that our current systems cannot address it? So, Mr. Speaker, unless it is the case that these courts are going to be established, Attorney General, unless it is the case that you want to establish this tribunal to use it for political persecution. At the regional level, you use the court to intimidate and jail political opponents. And at the district level, I said unless it is the case, because the current system that you have, if something is not broken, why fix it? If something, your court system, if it is the case that you have backlog of questions, and even if you go to cases, Mr. Speaker, and even if you go to, if you move further to clause 5, 7, and 8, and you even look at the people who are supposed to be appointed to be the chairperson and members of the tribunal, it is clear that it is job for the boys. That you are creating this one to say if somebody is qualified to be at a high court, being a member, then you appoint your party lawyers to be in there, intimidate people, put them before the tribunal, and get them jailed as quick as you can be. It can be. So, Attorney General, I am yet to be convinced that the tribunal you seek to establish will do something different that our court system is not doing. I am yet to be convinced on that note. And Attorney General, this is not the first time. You remember previously our senior Tachu, he said this is an illegality. He argued this to the Supreme Court, that tribunals are illegal. And for that matter, for you to now seek to introduce it at this moment, Mr. Speaker, it is addressing nothing unless you want to intimidate political opponents and rush cases, send it to tribunal, put your own panel, jail them for political reasons.
Honorable Habib, let me draw your attention to the fact that Chachu Chikata never went to court to argue against the tribunal system. He argued against the fast-track High Court.
Okay,
so he's
Mr.
not
Speaker,
here to defend himself, but this is a house of record. This is a house of record.
So, Mr. Speaker, if it is the case that he did not, I withdraw that part of it. But based on your correction, if the learned Chachu Chikata can argue that the fast-track High Court was even an illegality, why more talk about a tribunal then?
Have they brought the fast-track High Court to Parliament to be
was an illegality, and it was done for political persecution, how more or less than a tribunal? Then that means that tribunals are just there to put political opponents and jail them, rush the cases, put your 3 people. Because you are saying if you look at clause 5.6, is it the case that you don't have qualified judges? Why not strengthen the institution of your court? Why not employ more judges, employ more court workers so that you'll be able to? So, Mr. Speaker, I also support the clause 4 that it should be deleted. The entire clause 4 should be deleted. And Mr. Speaker,
thank you very much.
Think at this point, Mr. Speaker, I want to draw your attention that at this point, if we move further without taking a decision on clause 4, then it will be a great disservice to whatever we have to do with the bill. So the Attorney General have 2 options. Either allow clause 4 to be deleted or humbly withdraw this bill, and then we will all be free. I thank you, Mr. Speaker.
Yes, Honorable Majority Leader. I think we have heard the House a lot on the proposed amendment to clause 4. So please, will you allow me to moderate the House? I think that is my responsibility as a Speaker of the House. So you have taken a position and 3-4 people argue in favor. Some argued against. What do? We put the question and let the House take decision in moderating the House. Do you understand? So you have spoken, Abu has spoken, Habib has spoken. So if I want to hear the Attorney General and conclude on the issue and let the House take decision, what is my offense? You make the proposal, you have defended it. So it is for the consideration of the House. So for the House to consider it, I allow you to speak. I must allow, Attorney General was the only one who spoke from my side here. And I'm now giving the opportunity to the leader to also speak and let the House take decision.
I'm not opposed to your decision to moderate the House in a manner that would ensure peace. However, my role is to guide. Mr. Speaker, you realize that this is an important constitutional matter that touches on an arm of government, an institution of state, the judiciary. Mr. Speaker, that side, my colleagues to your right, they have decided so far to only allow the Attorney General to respond to the amendment. On my side,
please,
I have...
Please, they cannot decide
Mr.
the
Speaker,
person to allow to
Mr.
speak.
Mr. Speaker, for want of a better word, some of these things, let it slide. All I'm saying is that so far, it is only the learned Attorney General who has gotten up to oppose me. So
Yes.
far, we've only had one opposition to my application.
Yes.
Good. And I'm saying that apart from those who have spoken in support of the application or the motion for clause 4 to be deleted, I have the list from my side because we prepared before coming. We
Honorable.
prepared. Let me finish, Mr. Speaker.
Yes.
Let me finish. Then you make your ruling so that we can also take a decision.
Very
Please, I
well.
don't want to have a back and
Yeah,
forth
very
with
well,
you.
very
Thank
well.
you. For us, because we have a position on this, we prepared our colleague Hassan Tampoli, who is the vice chair of the Constitution and Legal Affairs Committee of the House. We have Honorable Bafo Ewa, who is a senior member at the bar and a member of the Constitution and Legal Affairs Committee. Mr. Speaker, we would want to plead with the chair that they be heard because this is amendment. And at consideration stage, members, Mr. Speaker, members must not be stampeded because if it's all about votes, Mr. Speaker, if it's all about votes, this side will never win a vote. And we are not here to win a vote. We are here to enrich democracy. We must be heard. If we always rush, take a decision. Mr. Speaker, I am pleading with you. I would always assist you and, give you every respect. But please, I have my side. I have my side. We are just 87. If you don't come to our rescue, who else will come to our rescue? Mr. Speaker, this is a Chobwe law. So please, my respected colleague, the majority leader, a man in whom I'm well pleased. At this point. Mr. Speaker, in spite of all the mischief he perpetrates against me, I know he's doing his job. So if he gives me uppercut, I let it go. I can't take it personal. But I know he's a true gentleman who believes in the fidelity of the law, including the Attorney General himself. The many cases he's done at the bar, these cases have been reported. He shouldn't dilute it with politics, learned Attorney General. Learned Attorney General, we know your records at the bar. We've cited your cases in our court, we know. So, Mr. Speaker, please, my three colleagues would want to also have a bite on my application. And after that, if the other side, they see no evil, hear no evil, we know. But, you can never tell tomorrow. This tribunal that will not have judges, but chairman, member, if you allow it to stay, and one day you come back into opposition, and some rogues find their way, what they will do in this country, Mr. Speaker, to conclude, let's be careful, like what Justice Atukuba told us this morning. Let's be careful. It may be your policy, but anybody who is not a proper judge is given judicial power at the district level, at the regional level. We know at that level things that happen. Mr. Speaker, sometimes civil litigation ends up in criminal matters. Let's be careful, colleagues in leadership, colleagues in politics. Let's be careful. Mr. Speaker, I will end it here. Please, after hearing the majority leader, please permit my colleagues to speak.
Honorable members, I still maintain that consideration stage is not a second reading of a bill. Consideration stage is not a second reading of the bill. I have sat, I have listened, though I wasn't here during the second reading of the bill. What we are doing was not different from the debate that I have listened to at the second reading stage. Because at the second reading stage, you can submit that the bill should not be passed. You can question the mischief that the bill is seeking to cure. You can question the principle underpinning the bill. But if you are moving an amendment on a clause, the debate of the second reading is over. The House have taken a decision to progress with the bill. That is why we are at the consideration stage. I've also been in this House for some time. We never had a speaking list at the consideration stage of a bill. This is the first time. You understand? So I do not like what is happening. Yes. Yes.
Thank you very much, Mr. Speaker. I can understand that at this stage, the debate will be heated because Clause 4 is at the very heart of this bill. Clause 4 is at the very heart of this bill. And the truth also is, as Speaker indicated, the arguments against Clause 4 turns out to also be the principle based on which there is opposition to the bill. So the two arguments are the same, which is any argument against this bill will sound like the arguments that occurred during the second reading when we analyze the principles of the bill. And so when I hear the Honorable Jinapo, I hear a repetition of what he said on the day when we were having the debate on the principle of the bill. I wasn't here when the minority leader spoke, but I would be surprised if his argument was materially different from what Honorable Jinapo also argued, essentially the same. Two things will happen. I think that it is good to have a healthy debate, but it is good also that when people are going to speak, they must be saying something different. But just repeating what others have said sometimes can be really very, boring. So let us also be guided by the Speaker in terms of how we manage our time in the chamber. But Mr. Speaker, let me state once again that I've heard Honorable Jinapo, and he is arguing that we should go for an amendment of the Constitution in order that we don't have anything to do with tribunals. Until we achieve that amendment, we have no other way than to respect what the Constitution says. And the Constitution says that we should have regional tribunals. The Constitution says we shall have regional tribunals. So if we are going to honor and respect our Constitution, if the Constitution says we should have regional tribunals, this Parliament cannot accept the existence of a Parliament and yet reject the existence of regional tribunals. That would be a contradictory argument. Because we have an oath which enjoins us to be committed to the Constitution and whatever the Constitution says, irrespective of our personal views about the Constitution. The Constitution says that there shall be regional tribunals. There shall be regional tribunals until the review takes place and Ghanaians vote amending the Constitution. There shall be regional tribunals. There shall be regional tribunals. So let us have regional tribunals, and when there's a constitutional review and Ghanaians say they don't want regional tribunals, then as a matter of fact, regional tribunals cease to exist upon the passage of a new constitution which outlaws regional tribunals. And I also listened to my brother, Honorable Jinapo, and he says that in every civilized democracy, you don't have a tribunal system. But you see, you misunderstand a tribunal system. What is a tribunal system? In this tribunal system, we have one chairperson and two other members. And the principle behind the tribunal system is not any different or does not radically depart from the principle underpinning the jury trial system. It doesn't depart materially from trial by jury because it is trial by your peers. Indeed, a tribunal system is far better than a jury system because in this instance, you have the judge, the chairperson whose qualifications are the same as a high court judge. The chairperson, the qualification for a chairperson are the same as a high court judge. Indeed, the law we are passing makes it possible for all the three members of the tribunal to be lawyers. The law makes it possible because it doesn't say one lawyer and then two other non-lawyers. It doesn't say so. It says a chairperson and two other persons. And then it defines a minimum qualification based on education and etc. But it can go up to a PhD holder. It can go up to a lawyer of 10 years standing at the bar, of 15 years standing at the bar, of 20 years standing at the bar. Indeed, more eligible than many of those who are sitting as high court judges today or circuit court judges today. So this is indeed far better than even a jury trial of your peers, because in this instance, the regional tribunal is made up of a chairperson who must have the same qualifications as a high court judge. So what's your problem? Why do you think that a high court judge who has the same qualifications as a person who is a regional tribunal chairperson will do better than a regional tribunal chairperson? They all have the same qualifications. They are all appointed through the same process. Through the same process. Why now? Why now? Because it is in the Constitution and we must respect the Constitution. It is in the Constitution and we must respect the Constitution. Indeed, it existed, and when the NPP came into office, the NPP removed it. It existed. So it has to come back because it's in the Constitution. And there's no basis for removing it when you haven't amended the Constitution. And I want to indicate, and I argue the same way when we're doing the second reading, that the perception that the tribunal system does not administer justice is just not right. It's just not right. Because excuse me, because we have operated the traditional system of justice with the high court judges, with the circuit court judges administering justice. And let me repeat what I said a few days ago. Today, Afrobarometer's report says that 50% of Ghanaians have no confidence in the judicial system as it is now. As it is now. The answer does not lie in building more courts. The answer does not lie in building more courts. The answer does not lie in appointing more high court judges. The answer does not lie in being more fast track. There is a fundamental problem of confidence in the system. Okay? And yet, the fact also is that when the tribunal system was introduced, the element of speed in the administration of justice was so effective in galvanizing public confidence in the tribunals. So let me indicate that the fundamental thing about these tribunals is the fact that we are defining the cases that they can handle, and then even more so, we are abridging the processes so that there can be expeditious trial of criminal matters. That is what it is. Now, as for the issue of trust, the issue of why now, and I hear your arguments and you create the impression that the tribunals are being established for the purposes of prosecuting political opponents. But that's not the case. Look at the jurisdiction of the court, the tribunals. Go and look at the jurisdiction of the tribunals. You will see that the range of issues for which politicians tend to be culpable are largely not within the remit of these tribunals. The range of issues, if you look at the jurisdiction of the courts, has nothing to do with a lot of the issues that the tribunals will, politicians get involved in or are alleged to get involved in. So, Mr. Speaker,
Honorable Minority Leader, with all due respect.
Mr. Speaker, if you think that the NDC is proposing the re-establishment of tribunals so that NPP members will be prosecuted, know very well that there will be a day when NDC will also not be in office and MPP will be in charge. So when you come into office, use the same tribunal to also prosecute NDC members. No, yes. Whatever it is, if you are prosecuted, and you have not committed a crime, it will be very difficult for you to be convicted. If you haven't committed a crime, you can be subjected to harassment, you can be hauled before any committee, you will be, your time will be wasted, and etc. But at the end of the day, it will be very difficult for a court or a tribunal to just push you into jail when nothing is established against you. Our system is civilized at least to that extent. As for time wasting, yes. As for harassment, you may be harassed. But you could be harassed without even being sent to a tribunal. You could be harassed just using the investigative bodies alone, without being sent to a tribunal. So it is not a tribunal that will be used to harass political appointees. It will not be a tribunal. I think that the tribunal will do us good if we do what we are doing, which is give them the power to determine matters expeditiously, because that is the major issue that Ghanaians have against the current system of administration of justice. So let me assure you, we are willing to listen to all the arguments and respond to them one after the other, but the fundamental thing is that until we amend this constitution, we cannot look this constitution in the face and say that as a parliament, we are not going to legislate the establishment of a tribunal system, because the constitution recognizes the existence of tribunal system for the administration of justice. That is fundamental. And if you accept that the constitution establishes a parliament and creates the office of member of parliament, you must equally respect the provision of the Constitution that says that there should also be a tribunal and that it should be led by chairpersons and then other members. Otherwise, you are contradicting yourself. You are really contradicting yourself. You can't accept the chapter that establishes Parliament and members of Parliament and reject the chapter that establishes tribunals and the members of the tribunal. I think that this argument really betrays some, fundamental flaw in the way that we are approaching the enforcement of our Constitution. So, Mr. Speaker, I urge colleagues that this is the position. It is constitutional. What we should do is how to refine it and make sure that it works until we amend our Constitution. And I'm sure that you will have a difficulty even convincing Ghanaians that the provisions on tribunals should be amended out of the Constitution, because you haven't convinced them that the regular courts are satisfying them in terms of administering justice. So they would like to try the alternative. Thank you very much, Mr. Speaker.
Honorable Tampoli.
Thank you very much, Mr. Speaker. Mr. Speaker, the matter before us is similar to a situation where you find somebody driving a car. He runs out of petrol, and he decides that petrol is a liquid. So maybe let me just put Fritol in the engine, and then the car will move. Mr. Speaker, what petrol can do, Fritol cannot do. Mr. Speaker, this tribunal system, during the Consultative Assembly, in fact, it's been captured in Professor Kwame Ninson's book on the evolution of the tribunal system. And the arguments and the debates have been captured in the book. Mr. Speaker, this is one of the issues that was voted upon, even at the time. Mr. Speaker, with time, the tribunal system was never abolished. It died a natural death. And if you read Professor Kumado's article on the transitional provisions, he labeled it, "Forgive us our trespasses." All the things that have been done during the course of the PNDC era, AFRC era, and all the military regimes were supposed to be part of our history and not to be continued. Mr. Speaker, we have had CDRs, Committee for the Defense of the Revolution. Mr. Speaker, we have had WDC, Workers' Defense Committee. We have PWD, People's Defense Committees. And Mr. Speaker, many of my colleagues here who were younger and older at the time knew about the excesses of some of these situations. Mr. Speaker, the tribunal system was used to abuse Ghanaians, some of whom lost their parents and are now within the NDC itself, because they believe that the NDC has reformed and the NDC is attractive and the NDC has jettisoned some of these situations. Mr. Speaker, when you go back to the tribunal system, you are reminding Ghanaians who have suffered under the tribunal system that we have not finished our democratic, we have not come to a situation where we have forgotten of the past. So, Mr. Speaker, we have not abolished the tribunal system. Mr. Speaker, the situation that we find ourselves in, that we should appoint people to go and sit on tribunals, and then the leader made a point that we can appoint anybody, including PhD holders and so on and so forth. Mr. Speaker, I beg to differ. I beg to differ. What we have right now, our democracy has matured. And it's very important that we do things that will advance democracy. What the Kufuor administration did, and what Atamo's administration did, and what Akufo-Addo administration did, was to correct the backlog of cases by creating more courts, strengthen the existing structure, recruit more judges, have more state attorneys, and so on and so forth. Mr. Speaker, that is the way to go. You cannot go back to this remnants of the revolutionary period. Mr. Speaker, then where do we find ourselves? It's absolutely necessary that we jettison this. Mr. Speaker, it's also very important to state that one of the recommendations of the Professor HKP from Prempe Constitutional Review Committee was that the tribunal system should be abolished and then deleted from the Constitution. Here we are spending precious time debating on something that has been, more or less recommended to be removed. So we are second guessing what the constitutional review exercise is going to be about. Mr. Speaker, let's wait and let Ghanaians decide whether it should continue or not. Otherwise, you are making the work of the president null and void. It's become a nullity. We spend resources to put up the committee to do the work. Allow them to complete their work. Let Ghanaians agree or not agree. If they agree, then we continue. Mr. Speaker, if you go to Section 5 of the transitional provisions, it talks about the discontinuance of the tribunal board and that the duties and functions and responsibilities of the tribunal board to be handed to the Judicial Council. What is it telling us? The Judicial Council has the capacity to do that kind of work that we want them to do. If there is a need for us to expand infrastructure, the Judicial Council should be able to do so. Mr. Speaker, this is a proposal that is coming from the Attorney General. There's no evidence that the judiciary or the Chief Justice has said that we don't have the capacity. So these are politically created courts to persecute opponents of the regime. But Mr. Speaker, with time, you will finish prosecuting your opponents. And like hyenas, when they cease to get meat, they will eat each other. They will finish eating us and they will come after you because they can't be sitting down idle. So Mr. Speaker, Auditor General report has already cited you. Auditor General's report. Look at the Auditor General report. Mr. Speaker, they will eat you like hyenas. The tribunals will eat you. So Mr. Speaker, let's be very, very careful. When we pass the OSP Act, under His Excellency Nana Addo Dankwa Akufo-Addo, one of the persons who came under attack was my very learned brother and senior, the majority leader. By the time that they left office, the OSP was now consuming MVP people. That should tell you something. It's not going to be one-sided. Let's hasten slowly. We are in a democratic dispensation. Let's expand infrastructure. Let's make sure that the structures will work. Yes, Afrobarometer says that 50% of Ghanaians don't have confidence in the judicial system. Mr. Speaker, similarly, they have said the same thing about Parliament. So should we abolish Parliament or should we create a second chamber? That's not the argument that we should be having here. Mr. Speaker, let's strengthen the existing administrative structures for the justice system and not try to replicate and duplicate the functions. And look, Mr. Speaker, some of the things that we are seeing here in terms of how soon they should dispense with cases, 30 days, 60 days, and all of that. Mr. Speaker, you are a senior practicing lawyer. Do cases end that way? So we are being told that whether you like it or not, regardless of any interlocutory matters or not, we are working with speed and not the justice that we are supposed to be getting for the people of Ghana. Mr. Speaker, I want to conclude by saying that in Tree, and let me say it in Tree, Aba Edibo Bano, Aba Edibo Techi, Aba Edibo Techi, and one Edibo Ba. Mr. Speaker, you can go ahead, you have the numbers, you have your way. Mr. Speaker, we will have our say, and we are reminding you for the hazard, for the record to bear, that one day, this dog that you are unleashing on Ghanaians will come and bite you. Aba Edibo Techino. I thank you, Mr. Speaker.
Yes, you have the floor, but kindly be brief.
Thank you, Mr. Speaker. Mr. Speaker, I support the submission for the deletion of the proposed section 4. Clause 4. Mr. Speaker, the tribunal which is being proposed to be established by this bill is not the same tribunal as provided for by Article 126 of the 1992 Constitution. Mr. Speaker, Article 126 of the 1992 Constitution does not provide for a tribunal which is an independent body, but it provides for a tribunal which is part of the judicial service. And thus, that is why, Mr. Speaker, under Clause 5 of the transitional provisions, the former Public Tribunal Board, Mr. Speaker, was abolished within 6 months of the promulgation of the 1992 Constitution. Mr. Speaker, and the functions thereof vested in the Judicial Council. Mr. Speaker, here we are. A tribunal system is being proposed to be established as an independent body. Mr. Speaker, independent of who? Independent of what? Independent of the judicial service? Mr. Speaker, that is exactly what is being proposed. Otherwise, it would not be independent. Mr. Speaker, that is clearly an unconstitutionality. That is why, Mr. Speaker, we are saying that it is unconstitutional. Mr. Speaker, Clause 4 clearly is an unconstitutionality to the extent that it proposes to be an independent body of the judicial service. And therefore, Mr. Speaker, this House cannot, Mr. Speaker, support it in that regard. Mr. Speaker, again, a regional tribunal, for instance, Mr. Speaker, is already established as part of the Superior Court of Judicature. Now, this bill is proposing to integrate a regional tribunal which is already established as part of the Superior Court of Judicature of this country to be part of a tribunal system which is being proposed to be established. Mr. Speaker, this is clearly an implied amendment of the 1992 Constitution by this bill. And Mr. Speaker, this is procedurally unconstitutional to the extent that, Mr. Speaker, it is inconsistent with the provisions of the Constitution for the amendment of the Constitution. Mr. Speaker, the regional tribunal is part of the Superior Court of Judicature. It cannot, Mr. Speaker, by this bill, be removed and made part of a public tribunal system. That is clearly a proposal to amend that provision, the portion of the Constitution. So, Mr. Speaker, Clause 4 clearly is an unconstitutionality and it should be deleted, Mr. Speaker. This is my humble submission.
Honourable members, please, I intend not to take more debates on the issue, but to put a question to the proposed amendment. Honourable members, the proposal by the minority leader is that Clause 4 of the bill be deleted. I'll put a question. As many as are in favor say aye. Aye. As many as are against say no. No. Honourable members, the noes have it. The Clause 4 is ordered to stand part of the bill. We are on Clause 5. Yes.
Mr. Speaker, I call for a short suspension. I call for a short suspension.
Very well.
I call for a short suspension, Mr. Speaker, so that we can engage.
Honourable Habib,
Mr. Speaker, I want to draw your attention.
You cannot put on your microphone and start speaking. Please.
Mr. Speaker, you said yes.
Please. Please. What is happening? Please, no. You don't have the floor.
Take your time. Take your...
Please. It's not looking good. Normally, if there is an application coming from the majority leader, I throw the application to the minority. That is what I do always. The request is for us to take suspension.
Mr. Speaker,
Please, if you are not going to speak to the request, kindly resume your seat.
Press your mic. Speaker,
Yes, there is a
with
request for
respect.
consideration.
Mr. Speaker, we want to help you. Help us. Mr. Speaker, we all want to, Mr. Speaker, we all want there to be peace in this house. Mr. Speaker, language, you may not intend, it may not be your intention to spite a member. But Mr. Speaker, sometimes the approach, just as sometimes you see through my actions and correct me, I can correct you. But Mr. Speaker, my colleague on his feet was first up, then the respected leader made the application for suspension. You want to know our view. And he's telling you that with the greatest respect, we are, the matter on the floor is a vote, which you made a declaration. We are challenging the ruling under Order 1513. The majority leader has also come with an application, which I know it is a strategy, because he suddenly rose and said suspension because he knows we have an application challenging the ruling. So he wants to arrest our application.
So,
Mr. Speaker,
Majority Leader, Minority Leader, with all due respect, when you were a majority leader, I was an opposition member. In a circumstances like this, if you make application of this nature, you are expecting the speaker to ignore the application and hear. So what has changed?
Speaker, that is not what I'm saying. And you are presiding. We are here at the front bench. We know him. Mr. Speaker, we know him. And we are drawing your attention, Mr. Speaker.
Please.
Mr. Speaker, most of the times when he speaks, you don't ask him questions. This is my worry. Please, let us also make the point. I agree with you if you say that upon his application, because he knows his mischief, now he's pretending that he's busy on his phone. You are not pretending to knowing the problem you are causing. But our appeal will be heard. Mr. Speaker, all we are saying is that before responding to his request for suspension, we have a preliminary matter. That is our prayer.
You see, the request is not coming from any ordinary person, but leader of government business. So please.
Mr. Speaker, don't worry. I will solve it. Mr. Speaker, don't worry. It's okay. Mr. Speaker, let the record reflect that if he wants us to take a short suspension, let the record reflect that the vote that was just taken, we, the minority, are challenging the decision of the speaker in accordance with Order 1513. If he wants us to take a short suspension before this is done, Mr. Speaker, so be it. We don't have a problem. But let it be on record that we are challenging the no vote which arrested our application. Mr. Speaker, that is all we're saying. We're challenging the yes vote. But if he wants us to take a short suspension, so he organizes his members so that they come in for the head count. That is all he's doing. But he's a majority leader. I can understand. No problem. This is one of the tools he should deploy in circumstances like this that he knows he will lose. It's okay. Mr. Speaker, you may decide on his application.
Honourable members, the House is temporarily suspended. All members, you may kindly take your seat. All members, we've taken decision on clause 4. So can we move to clause 5? Yes.
Mr. Speaker, we had moved clause 5. Sorry. Okay, sorry.
Yes, Honorable.
Speaker, respectfully, there was a situation before you called for suspension.
Very well.
And I thought you were going to proceed with that situation for us to have it resolved before you proceed.
Very well. The floor is open for the submission. Because I have not seen Habib. But if you have the authority, you may please raise the issue.
Yes, Speaker, Habib requested that we look at 151, order 151 then, and I thought that we were going to proceed on that tangent.
Read order 151 and raise the issue.
Mr. Speaker.
Yes.
We need to know whether he is raising an issue or Habib is raising an issue. Because Habib can choose to be in the chamber. If he has decided not to be in the chamber, whatever issue he was raising, which is a personal matter, is deemed abandoned. Is deemed abandoned. So if he wants to raise the issue, he should man up and raise the issue. And don't bring Habib into the equation. So be bold. Raise the issue. Raise the issue, but don't say Habib, no. If you want us to wait, we can wait. We can give you time for Habib to come. We can give Habib time to come. I said we can give Habib time to come. You know, he's supposed to be here. So unless you want to raise it, if you want to raise it, I don't have a problem.
Mr. Speaker, I was in this chamber when my colleague raised the issue. That was the matter for which this House was suspended. At the time the issue was raised in reference to 151, Speaker, that was when. Speaker, unless Hazard has not captured it, when that was raised, they were 23. If they have come and we are insisting that whatever Habib said is what we are proceeding with.
Honorable Deputy Minority Whip. Honorable Deputy Minority Whip. Habib was about raising the issue, but I did not give him the floor to do so because Majority Leader raised the issue of suspension. That is why he is saying that Habib having not raised the issue, if you are mindful, you can raise the same issue and we'll give it consideration. If not, we make progress.
Speaker, respectfully, I come under order 151. 1513 in particular, and with your permission, I read. Speaker, 1513. A member may challenge the decision of the Speaker on the voice vote, and the Speaker shall determine whether to call for head count or electronic vote. Speaker, the basis of our call on you, respectfully, is to say that we would need a head count on this matter. We will need, Speaker, we will need a head count of each and every member to determine the true reflection of the votes. Speaker, I so pray.
Honourable members, by the rules, if order 1513 is invoked, challenging the decision of the voice votes, the procedure is spelled out in order 152. And 1521 says that the Speaker shall take the vote of the House in the case of a head count by calling upon members who support or oppose the question to rise in their place successively. On that note, I will call on the minority who supports the motion to stand up to be counted. Yes.
Speaker, with respect, before we take the head count, I want to bring to your attention a preliminary observation. Speaker, with respect, when the application was made and the majority leader requested for suspension, they had only 37. Mr. Speaker, the people in this room who are now going to be part of the appeal process were not here. They were not here. How can they? They were not part of the earlier voting. The majority leader used this strategy to bring them in. If you are not part of the original vote, how can you be part of an appeal process? Mr. Speaker,
so
I just want to bring to your attention.
Are
they
you,
were not here.
by your suggestion, saying I should not proceed with the process?
I haven't said so. I'm saying I am bringing to your attention a preliminary objection matter. The preliminary observation is that when we voted earlier, the subject matter of the recount, the head count, the subject matter of this appeal, the majority leader, I told you that he had a strategy to request for suspension so that he uses the suspension, which has taken 5 hours of suspension, to populate this chamber. How can they participate in the voting? All these people who have suddenly entered the room, all these people, 5 hours, all of a sudden, and you said they should participate in the process.
Honourable Minority Leader,
Mr. Speaker, let me finish my
with
observation.
all due respect, I have never ordered any counting. Honourable members, let's listen. I have never ordered any counting. For that matter, I wouldn't be able to determine the numbers. Now, Jerry has buttressed the points, and I'm following the procedure in order 152 and calling for head count. That is why I'm calling on the minority to stand up to be counted. So,
Mr. Speaker, respectfully, Mr. Speaker, without prejudice to the processes you have initiated, I am saying that there is a preliminary observation I have made. And I want your determination on the preliminary observation. Mr. Speaker, the preliminary observation I have made is that, Mr. Speaker, at the time of the first voting, Mr. Speaker, there were only 35. The majority leader has used 5 hours. 5 hours to marshal his members so that, Mr. Speaker, he can tilt the head count.
So are you calling on me to rule?
Mr. Speaker, yes. I would want to. So let me finish the application.
Very well.
Let him oppose it and rule. So let me finish. Mr. Speaker, it is our case as minority that those who participated in the no vote, Mr. Speaker, the no's were just 35. We counted. As we speak, Mr. Speaker, the foreign minister was not here. The respected finance minister was not here. Mr. Speaker, the lands and natural resources minister was not here. Mr. Speaker, all those backbenchers, they populated this room. They were not here. They were not here. Now, Mr. Speaker, they have brought them to participate in a vote they were not part of originally. How can you do this? Mr. Speaker, how is this possible?
Honorable Majority Leader, just resume your seat. Honorable Majority Leader, Majority Leader, just take it easy, resume your seat. Please, conclude.
Mr. Speaker, those who participated in the no vote, the application was to the effect that we should delete clause 4 of the bill. And you put the question, the no's, we counted. And it is true you didn't order any counting. But, Mr. Speaker, at that material time, Mr. Speaker, you may protect me. Mr. Speaker may protect me. The shouting. Mr. Speaker, you may have to protect me. The shouting. The shouting.
Please. Honorable members, with all due respect, let's listen to each other.
The minority leader must be heard.
Let's listen to each other.
Mr. Speaker, you call the vote. And when you call the vote, the ayes voted. I was the applicant. And my prayer was to the effect that clause 4, entire clause 4 be deleted. And Mr. Speaker, after listening to all the argument, you put the question. The ayes voted, and the no's were just 35. Mr. Speaker,
well,
then we
Honorable
rose.
Minority Leader, with the issue that you have raised, I got to the issue that you have raised. But let me advent your mind to Standing Order 1522. It reads, a member may vote on any question put, even if the member did not participate in the deliberation on the matter.
Mr. Speaker,
this is Standing Order 1522
Mr. Speaker,
of the rules book.
Mr. Speaker,
so what issue are you raising?
Mr. Speaker, respectfully, 1522 talks about deliberation. And that's not the issue I'm raising. Mr. Speaker, that is different from the issue I'm raising. The issue I'm raising is to the effect that, Mr. Speaker, the majority leader used a means of mischief, bad faith, Mr. Speaker, to create this scenario. Mr. Speaker, he suddenly rose on his feet when our application for the head count was about being moved. He now said that the House should be suspended. And Mr. Speaker, you obliged him by saying that he's an important person. Mr. Speaker, can you, Mr. Speaker, I respect Honorable Adongo. I know he's a member of the Bank of Ghana board. Mr. Speaker, see where he's seated. They strategically brought him here to come and heckle the minority leader. Mr. Speaker, see where he's seated. A member of the Central Bank board. A happy member, Mr. Speaker.
Honorable Minority Leader, you raised an issue calling on me to provide a ruling.
Yes. They should
and
allow
I'm
me to
drawing
make
your
my application.
attention to a particular order.
Mr. Speaker, they should make me.
Will you
Mr. Speaker,
allow
I'm
me
making my point, but they
to
are
deliver a
Mr.
full
Speaker,
ruling?
The house, there's too much noise in the house. It's creating problems. Mr. Speaker, bring them to order. I need to make my application. Mr. Speaker, my argument is that Order 1522 in its form and shape is talking about deliberation, meaning that when a member is not even in the chamber, he can come and vote. I agree. That is not what I'm saying. What I am saying, and the invitation to you as a presiding officer, is to the effect that where members are not part of a voting system, they did not vote, they were not here to vote, but a majority leader, knowing that he is losing a case, decides to apply for suspension. Then after 5 hours, decides to populate. Why are you turning your face this way? Decides to populate the chamber with, Mr. Speaker, backbenchers who were not in the chamber, cabinet ministers who were not in the chamber. Mr. Speaker, the argument is whether or not those who did not participate in the voting can now come and use their presence to tilt the voting in a certain direction. Mr. Speaker, that is a call on you. Mr. Speaker, I submit that they not being in the chamber, they are stopped.
Honorable Minority Leader, if you call on the Speaker, then you resume your seat and also listen to the Speaker
they are
as well.
making noise. I can't hear you. They are making noise. I can't hear you.
I'm saying that once you call on the Speaker, then you resume your seat and then listen to the Speaker. Or if there is any response from the majority side, we take the response and then you listen to the Speaker and we conclude the issue. So, Majority Leader.
Mr. Speaker, the matters are very simple. He wants a head count. As for where I get the MPs from, that is not his business. Where I get the MPs from is not your business. I have always said that the practice of this House has been that you don't need everybody in the chamber to carry out business. But when a vote is about to take place, we will find the numbers when we need them. Mr. Speaker, it should be known that this is a side that is in government. If you look at the cabinet and the ministers, a majority of the ministers are members of parliament. About 90% of the ministers are members of parliament. And many other members of parliament are serving on boards. Many others are chairing committees with international responsibilities. So it is not at all times that on every vote, I will have everybody sitting in this chamber. But when reasonable time is given, we will make sure everybody is in this chamber. So, as for your arguments, I don't see the basis of the arguments. The Speaker has drawn your attention to the standing orders. The standing orders say that the fact that a member did not participate in the prior deliberations. Deliberations in this House includes voting. It includes the debate and the voting. That is the deliberation in this House. So the fact that members were not in during the first vote doesn't mean that when they arrive and then you are going to do head count, they cannot be counted. Because what happened earlier was deliberation of the House, including the vote that took place. What you are saying, that there were 36 people here, is clearly untrue. Totally untrue.
the only person who can certify the number of people in the chamber is the Speaker. And the Speaker did not count. The Speaker took a voice vote. You are demanding a head count. So it is now that the Speaker is going to count. And the numbers that the Speaker gets now is a reflection of those who have voted for the matter. That's how this House is managed. So I plead with you, if you don't want more people to come in, let's take the head count now. Because the more you delay us, the more people come in. As you can see, the foreign affairs minister was in the Volta region with the president. And I called him and he came back. There are people who came all the way from Northern region. There are some of our colleagues here who were in Yendi to attend the 3 days, Adua of our late King Diana. Because of you, I have brought all of them back. So I don't know what the basis of your objection is. So you have called for head count. Let's do the head count and move on, Mr. Speaker.
Honorable members, I think I've listened to the minority leader as well as the majority leader. This is what the chair has to say. Honorable members, by no parliamentary procedure can a speaker be called upon to rule on observation. The fact that the majority leader managed to bring the number or so and so, I have not ordered any counting. So that clearly is an observation by the minority leader. In no democratic parliament would a person presiding be called upon to rule on observation. That is unknown to our rules and the practice of this House. Secondly, the procedure is clear that when Order 151(3) is invoked, the person presiding must apply the procedure set out for it in Standing Order 152. In dealing with Standing Order 152, Standing Order 152(2) states clearly and unambiguously that a member may vote any question put even if the member did not participate in the deliberation of the matter. I therefore find the issue raised by the minority leader unmeritorious, frivolous, vexatious, and baseless in terms of our procedure. It is therefore dismissed. Honourable members, I will call on the minority who voted aye to stand up to be counted. Honourable members, the call is for the minority to stand up to be counted.
Speaker,
Clerk at table.
Speaker,
on this note,
Speaker,
you may do the counting.
I am on my feet with an application. Mr. Speaker, before you proceed to do the head count, the Constitution provides under Article 104(1)
except as otherwise provided in this Constitution. Matters in Parliament shall be determined by the majority of members present and voting, with at least half of all members of Parliament present. So, Mr. Speaker, since we are going to take a decision, I hold a view that to ensure fidelity to the Constitution, let us first establish that Parliament as constituted now, we have a decision-making quorum. And Mr. Speaker, I am moving that currently this House is not properly constituted for the purpose of decision-making. We are not properly constituted, so we need to cross the first leg before we get to the second leg of the head count. This is a constitutional bona fide. 104 requires that there must be at least 138. So, Mr. Speaker, let us establish that. That is fundamental. Since the majority leader says that he has more numbers, it's fine. Let's establish that. And you must certify that first. You must certify that first, that we have a decision-making quorum. Then we can move to the next step to do the head count.
Honorable members, with all due respect, there is an application on the floor. And when the application is on the floor, you deal with that application. You don't abandon that application to take another application.
You can't.
This is not how things are done. There is application by the minority, deputy minority chief whip, which application we have to deal with.
Mr. Speaker, you have every right to intervene, but sometimes I am tempted to believe that you don't pay attention to all my submissions. Mr. Speaker, preliminary, please. When the majority leader was on his feet, everybody here was quiet. Stop this. Stop this. Stop this. Stop this. And the speaker will not reprimand you. When it is us, he will reprimand. When it is you, he doesn't reprimand. The speaker is one-sided. Mr. Speaker, I call for immediate suspension. Mr. Speaker, I hereby apply for suspension of the House. When the majority leader applied for suspension, you granted it. Mr. Speaker, I call for suspension. Mr. Speaker, when the majority leader called for suspension, you granted this application. I hereby call for suspension of the House for some 5 minutes.
Majority leader.
Yeah, Mr. Speaker, you see, on several occasions, I rose up. You were also standing there. I waited to catch the eye of the speaker before I will utter a word. This last instance, I actually stood up first to try to catch the eye of the speaker. You stood up. You did not wait to catch the eye of the speaker. You just put the mic on and you started talking. He didn't call you. He didn't call you. He didn't call you. You see, so when you say that, when you do that, then you turn and accuse the speaker that he's being unfair, he's being one-sided, and etc. It's not fair. I will never open my mouth until I have clear instruction from the speaker that I never do that. You watch. You watch me carefully. You watch me carefully. I never speak until I have caught the eye of the speaker. He has given me indication that go ahead and speak. So when people react from this side, it is because, truth be told, you're not going according to the rules. You are not. You are not going according to the rules. When we came, you were not even in the chamber. Speaker asked him whether or not the issue of head count was still pending. Then he got up and said it was Habib And we said, no, wait. If you want to raise the question of numbers, go ahead and do it. Don't mention Habib. So we proceeded to give him the opportunity to raise an issue under Order 151. And so what we have to do is to count the heads. Let me assure you, let me assure you that we respect. If we didn't respect you, we would not suspend and get everybody in the chamber. It's a sign of respect. It's a sign of respect. So also respect us by allowing us to do the head count so that we can continue. I can assure you that even if we will sit here till tomorrow morning, this bill will pass it today. We will pass it today. You can filibuster, you can do all the things that you want to do. I have your time. I have your time. We will pass this bill today. So you can go on. You can go on. Those of us who have done student politics, this is common. We go for a NUCS meeting and we filibuster until 4 a.m. when everybody is sleepy. Then that's when we take the vote. So if you want that, we can do NUCS politics here. As for this bill, we will pass it today.
Yes, Minority Leader. Yes, Minority Leader.
Mr. Speaker, Mr. Speaker, a day or so ago, you sat there was communication here, and you said you heard. The Minister for Lands and Natural Resources is being abusive. He is abusing me. Mr. Speaker, he is abusing me. And, Mr. Speaker, when we talk, it's as if we are complaining, but that is the truth. We are being treated as if we are orphans in this chamber. Mr. Speaker, you will always reprimand our side. When it gets to the minority leader, questions upon questions. But when it is your side, no question. You gave me the opportunity to speak. Minister for Natural Resources was shouting, abusing me. No bread from the presiding officer.
Honorable Minority Leader,
Speaker, it is,
with all due respect,
Mr. Speaker, with all due respect to me
I will not take it anymore from you to accuse me of unfairness. It's enough. I cannot take it anymore. I can't take it anymore. Every day, you accuse me of being unfair. This is not how I expect leaders to treat me.
Mr. Speaker, I am expressing a feeling. Mr. Speaker, I'm expressing a feeling and how they are reacting to me. Mr. Speaker, we are only 87. If the presiding officer doesn't protect us, who else will protect us? Who else will protect us? We are just 87 in this chamber. They come to intimidate. Even if you want to speak, they don't want you to speak. Who else will protect if you don't protect us? I am protesting and it's my right. It's not against your person. Protect me and protect the minority. The minority must be protected. Our voice must be heard. That is the law. It is in our standing orders. Mr. Speaker, it is our case that since we have a preliminary objection issue regarding decision-making quorum, if you make a determination that you can only we can only raise it after the head count, I will resume my seat. But our case, we want Hansa to have it, that once a constitutional issue has been raised, all other matters must stay until that matter is determined. This is our case. This is our case. So if you make a determination, we'll be obliged.
Very well, I'll make
and we'll rely on your
the
decision.
Determination. Honorable members, a decision-making quorum is supposed to be raised at the point of making the decision. Now, Order 151 is invoked to challenge a decision that has already been made. So if Order 151 is invoked to challenge a decision that has been made, the procedure available for us is Standing Order 152. You do not go to raise another quorum when a motion has been moved to challenge a decision that has already been taken. So by our rules, once a motion is moved to challenge a decision of the Speaker, the procedure available is Standing Order 152. That is what we are adopting. Honourable members, when the procedure is set down for a right to be exercised, it is only that procedure that will have to be followed in exercising the right. Therefore, let's follow the procedure. Those who voted in support, stand up to be counted. Clerk at table, you may do the counting. So, according to the clerks at table, they have finished, so you may kindly resume your seat. They have finished, so you may resume your seat. Those who voted no, stand up to be counted. Honourable members, you can now resume your seats. Honourable members, declaration of the results. The total votes, or let's say those who voted aye, after counting, they numbered 16. Those who voted aye, who were up to be counted, is 134. Honourable members, by the Supreme Court decision in the case of Justice Abdullahi versus Attorney General, when the person presiding is a deputy speaker, he is entitled to vote. Accordingly, I am also voting aye. So the votes, I'm also voting no. I am voting no. So the votes, the total vote for the no is 135. The speaker is added. Now, the total vote cast. Honourable members, the total vote cast is 151. And total vote of 151 satisfy the constitutional requirement in Article 104. Therefore, Clause 4 is ordered to stand part of the bill. Yes, Minority Leader.
Mr. Speaker, we have done our own counting of the majority members. Mr. Speaker, they are 113. But, Mr. Speaker, in the interest of democracy, we haven't registered our protest. Okay. Mr. Speaker, since the majority leader has indicated that they will not listen to the views expressed, including that of organized labor, Mr. Speaker, we are leaving them. Debbie. I take responsibility. Let's go. There's no point. Mr. Speaker, the majority leader has let the cat out of the bag. He says that the door is shut. It is not only the minority that is raising issues against this bill, but organized labor has also done so. If he says they want to go ahead, Mr. Speaker, if he says they want to go ahead, and Mr. Speaker, when the majority leader speaks with all his authority, he says, today, he says he will pass. Mr. Speaker, the Constitutional Review Committee has spoken against this bill. They said they will do what they want to do. Mr. Speaker, are Democrats. We are not going to be part of this Rambo style of, Mr. Speaker, destroying the judiciary. They started by sacking the Chief Justice. They started by sacking the Chief Justice. After sacking the Chief Justice, they also allowed contingency fund account to be garnished. Now they want tribunal to be made up of non-lawyers, non-judges, to prosecute people. Mr. Speaker, they should do what they want to do.
On point of relevance, you are being out of order. Yes, Majority Leader.
Yeah, Mr. Speaker.
Majority Leader.
Mr. Speaker.
Honorable members. Honorable members, order. Honorable members, order. Honorable members.
Mr. Speaker.
For the purposes of clarity,
yeah.
Let me repeat the results. The minority who voted aye were counted 16. The majority who voted no were 134. And the decision of the court in Justice Abdullahi versus Attorney General is that when the person presiding is a deputy speaker, he represents a constituency, therefore his vote cannot be taken away from him. I'm therefore exercising my vote to support the no, making the no 135. The total number of vote cast is 151. Honorable members, the Supreme Court's decision in the case of Justice Abdullahi versus Attorney General is now part of our Standing Order 1525. And I read, where a deputy speaker or a member is presiding, the deputy speaker or a member shall communicate his personal votes to the clerk at the table to be added to the collated results before the results of the vote are declared. So the decision of the court is captured by our own standing order. So the total vote for today is 151. Honourable members, can we make progress? Clause 5. Chairman of the committee.
Mr. Speaker, we had already taken clause 5, but let me just go over it. Amendment proposed, head note, delete tribunals and insert.
We have taken a vote on the 5 before he brought us back to 4. So we now move to clause 6.
6, yes. Mr. Speaker, rightly so.
So you may move clause 6.
Relationship between tribunals and the judicial system.
Mr. Speaker, clause 6, amendment proposed, delete tribunals and insert tribunal. I so move, Mr. Speaker.
Honourable members, the proposed amendment by the chairman of the committee is for the consideration of the House. Any further amendment? In the absence of any further amendment, I'll put the question. Those in favor say aye. Aye. Those against say no. Honourable members, the proposed amendment is ordered to stand part of the bill. I will then put the question on entire clause 6 in the absence of any further. Yes, chairman of the committee.
Mr. Speaker, there's a further amendment to clause 6(4). The proposed amendment is to add regional tribunals as A. So a district tribunal is bound by a decision of A, regional tribunal, the regional tribunal, the High Court, the Court of Appeal, and
I'll put a question. Those in favor say aye. Aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill, and I will direct the drafters to renumber clause 5(4). I will then put a question on the entire clause 6(4). I will then put a question on the entire clause 6. As many as are in favor say aye. Aye. Those against say no. The ayes have it. Clause 6 is ordered to stand part of the bill. Clause 7.
Composition of regional tribunal.
Speaker, amendment proposed, subclause 1, paragraph B, delete 1 and insert A. I so move, Mr. Speaker.
Yes. Honorable Chairman of the committee, have you advented your mind to Article 142B? Why are you trying to change the constitutional language? The constitutional language is as captured here. So why are you changing it? Have you seen it?
Mr. Speaker, I'm minded to avert my mind to the constitutional provision.
You are minded to?
Yeah, so I will abandon the.
Very well. The proposed amendment abandoned. Honourable members, I will then put a question on clause 7. As many as are in favor of clause 7 standing part of the bill say aye. Those against say no. The ayes have it. Clause 7 is ordered to stand part of the bill. Clause 8.
Qualification of members of a regional tribunal.
Chairman of the committee.
Speaker, amendment proposed, subclause 1, line 1, after with, delete clause 1 off. I so move, Mr. Speaker.
All members, the proposed amendment is for the consideration of the House. Any further amendment? In the absence of any further amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Chairman of the committee, VI.
VI, amendment proposed, Mr. Speaker, subclause 1, paragraph B, delete and insert the following. I so move.
Honourable members, the proposed amendment is for the consideration of the House. Any further amendment? In the absence of any further amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. I will then put a question on entire clause 8 in the absence of any further amendment. Those in favor say aye. Those against say no. The ayes have it. Clause 8 is ordered to stand part of the bill. Clause 9.
Composition of district tribunal.
Chairman of the committee.
Speaker, I want to abandon clause 9. It will run the same way as clause 7. I so abandon, Mr. Speaker.
Very well. I will then put a question on entire on clause 9. Those in favor say aye. Those against say no. The ayes have it. Clause 9 is ordered to stand part of the bill. Clause 10.
Qualification of members of a district tribunal.
Chairman of the committee.
Speaker, no proposed amendment.
It is for the consideration of the House. Honourable members, any proposed amendment? In the absence of any proposed amendment, all members, I'll put a question. Those in favor of clause 10, standing part of the bill, say aye. Those against, say no. The ayes have it. Clause 10 is ordered to stand part of the bill. Clause 11.
Appointment of chairman of tribunal and panel members.
Chairman of the committee may move amendment VIII.
VIII, Mr. Speaker, amendment proposed, subclause 1, delete and insert the following as advertised on page 16. I so move, Mr. Speaker.
All members, the proposed amendment by the chairman of the committee is for the consideration of the House. In the absence of any further proposal, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Now, I'll put a question to entire clause 11 in the absence of any further amendment. Those in favor say aye. Those against say no. The ayes have it. Clause 11 is ordered to stand part of the bill. Chairman of the committee, you may move the new clause after clause 11.
Mr. Speaker, with your permission, may I move that after clause 11, insert the following new clause as captured on page 16. I so move, Mr. Speaker.
All members, the proposed amendment is for the consideration of the House. Any further amendment? In the absence of any further amendment, I'll put a question on the new clause. Those in favor say aye. Those against say no. The ayes have it. The new clause is ordered to stand part of the bill. Clause 12.
Retirement and resignation of chairman of regional and district tribunals.
Chairman of the committee.
Speaker, no advertised amendment.
It is for the consideration of the House. All members, any proposed amendment? In the absence of any proposed amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 12 is ordered to stand part of the bill. Clause 13.
Removal of chairman of tribunals and panel members.
Chairman of the committee.
Speaker, no advertised amendment.
It is for the consideration of the House. All members, do you have any proposed amendment? In the absence of any proposed amendment, I'll put a question on clause 13. Those in favor say aye. Those against say no. The ayes have it. Clause 13 is ordered to stand part of the bill. Clause 14.
Code of conduct and disciplinary rules.
Chairman of the committee.
No advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment? In the absence of any proposed amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 14 is ordered to stand part of the bill. Clause 15.
General jurisdiction of tribunals.
Chairman of the committee.
Mr. Speaker, no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment to clause 15? I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 15 is ordered to stand part of the bill. Clause 16.
Jurisdiction of regional tribunal.
Chairman of the committee.
Mr. Speaker, no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment? I'll put a question. Those in favor of clause 16 standing part of the bill say aye. Those against say no. The ayes have it. Clause 16 is ordered to stand part of the bill. Clause 17.
Powers of regional tribunal.
Speaker,
Chairman of the committee.
Clause 17, amendment proposed, paragraph B, line 2, delete may and insert has power to. I so move, Mr. Speaker.
It is for the consideration of the House. Honourable members, any further amendment? I'll put a question on the proposed amendment. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment to clause 17 is ordered to stand part of the bill. Now I'll put a question on the entire clause 17. As many as are in favor say aye. Those against say no. The ayes have it. Clause 17 as amended is ordered to stand part of the bill. Clause 18.
Decisions of regional tribunal.
Chairman of the committee.
Mr. Speaker, clause 18, amendment proposed, after subclause 1, insert the following new subclause as advertised on page 17. I so move.
Honourable members, the proposed amendment is for the consideration of the House. Any further amendment? In the absence of any further amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment to clause 18 is ordered to stand part of the bill. Now I'll put a question on the entire clause 18. Those in favor say aye. Those against say no. The ayes have it. Clause 18 is ordered to stand part of the bill. Clause 19.
Jurisdiction of District Tribunal.
Chairman of the committee.
Mr. Speaker, no advertisement.
It is for the consideration of the House. Honourable members, any proposed amendment? In the absence of any proposed amendment, I'll put a question on clause 19. Those in favor say aye. Those against say no. The ayes have it. Clause 19 is ordered to stand part of the bill. Clause 20.
Powers of District Tribunal.
Chairman of the committee.
Mr. Speaker, no advertisement.
It is for the consideration of the House. Honourable members, any amendment? Those in favor of clause 20 standing part of the bill say aye. Those against say no. The ayes have it. Clause 20 is ordered to stand part of the bill. Clause 21.
Decisions of District Tribunal.
Chairman of the committee.
Mr. Speaker, clause 21, amendment proposed after subclause 1, insert the following new subclause as advertised on page 17. I so move.
Honourable members, the proposed amendment is for your consideration. Any further amendment? In the absence of any further amendment, I'll put a question. Those in favor of the proposed amendment standing part of the bill say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Now the question is on clause 21 as variously amended. Those in favor say aye. Those against say no. The ayes have it. Clause 21 is ordered to stand part of the bill. Clause 22.
Concurrent jurisdiction with other courts and limitations.
Chairman of the committee.
Mr. Speaker, no advertisement.
It is for the consideration of the House. Honourable members, any amendment to clause 22? In the absence of any amendment, I'll put a question to clause 22. Those in favor say aye. Those against say no. The ayes have it. Clause 22 is ordered to stand part of the bill. Clause 23.
Matters excluded from the jurisdiction of a tribunal.
Chairman of the committee.
Mr. Speaker, clause 23, amendment proposed after paragraph B, insert the following new paragraph. I so move, Mr. Speaker.
Honourable members, the proposed amendment is for your consideration. Any further amendment? In the absence of any further amendment, I'll put a question onto the proposed amendment. Those in favor say aye. Those against say no. Honourable members, the ayes have it. The proposed amendment is ordered to stand part of the bill. Now, I'll put a question on the entire clause 23 as amended. Those in favor say aye. Those against say no. Honourable members, the ayes have it. Clause 23 is ordered to stand part of the bill. Clause 24.
Reference to the Supreme Court.
Chairman of the committee.
Mr. Speaker, no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment? In the absence of any proposed amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 24 is ordered to stand part of the bill. Clause 25.
Rules of procedure before a tribunal.
Chairman of the committee.
Mr. Speaker, clause 25, amendment proposed after subclause 1, insert the following new subclause as advertised on page 17. I so move.
Honourable members, the proposed amendment is for your consideration. Any further amendment? I'll put a question onto the proposed amendment. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment to clause 25 is ordered to stand part of the bill. I'll put a question on the entire clause 25 in the absence of any further amendment. Those in favor say aye. Those against say no. Honourable members, the ayes have it. Clause 25 as amended is ordered to stand part of the bill. Clause 26.
Mode of trial.
Mr. Speaker.
Chairman of the committee.
No advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment to clause 26? I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 26 is ordered to stand part of the bill. Clause 27.
Right to legal representation.
Chairman of the committee.
Mr. Speaker, no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment? In the absence of any proposed amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 27 is ordered to stand part of the bill. Clause 28.
Application of Evidence Act 1975, NRCD 323.
Chairman of the committee.
Mr. Speaker, amendment proposed under 28 is to delete the entire clause. I so move.
Honourable members, the proposed amendment is for the consideration of the House. Any further amendment? I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 28 is ordered to be deleted from the bill. Clause 29.
Proceedings to be open to public.
Chairman of the committee.
Mr. Speaker, no advertisement.
It is for the consideration of the House. Honourable members, any proposed amendment? In the absence of any proposed amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 29 is ordered to stand part of the bill. Clause 30.
Live broadcast of public interest cases before regional tribunal.
Chairman of the case, Chairman of the committee.
Mr. Speaker, no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment to clause 30? In the absence of any proposed amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 30 is ordered to stand part of the bill. Clause 31.
Restrictions on media coverage of proceedings of district tribunal.
Chairman of the committee.
Mr. Speaker, no advertised amendments.
It is for the consideration of the House. Honourable members, any proposed amendment to clause 31? In the absence of any proposed amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 31 is ordered to stand part of the bill. Clause 32.
Compliance with procedural safeguards.
Chairman of the committee.
Mr. Speaker, clause 32, amendment proposed is to delete the entire clause. I so move, Mr. Speaker.
Now, members, the proposed amendment is for the consideration of the House. Any further amendment? Those in favor say aye. Those against say no. The ayes have it. Clause 31 is ordered not to stand part of the bill. Should be deleted. Now, clause 32 is ordered not to be part of the bill, is deleted. And I direct the drafters in view of the deletion in 28 on 31 to check the renumbering. Clause 33.
Application of sections 34 to 42.
Chairman of the committee.
Mr. Speaker, there's no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment to clause 33? Honourable members, in the absence of any proposed amendment, I'll put a question. Those in favor of clause 33 standing part of the bill say aye. Those against say no. The ayes have it. Clause 33 is ordered to stand part of the bill. Clause 34.
Mode of instituting proceedings.
Chairman of the committee.
Mr. Speaker, no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment to clause 34? In the absence of any proposed amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 34 is ordered to stand part of the bill. Clause 35.
Service.
Chairman of the committee.
Mr. Speaker, no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment to clause 35? In the absence of any proposed amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 35 is ordered to stand part of the bill. Clause 36. Clause 36. Clause 36.
Defense of accused person and preliminary objection.
Chairman of the committee.
Mr. Speaker, no advertised amendments for this.
It is for the consideration of the House. Honourable members, any proposed amendment? In the absence of any proposed amendment, I'll put a question. Those in favor of clause 36 standing part of the bill say aye. Those against say no. Honourable members, the ayes have it. Clause 36 is ordered to stand part of the bill. Clause 37.
Electronic service.
Chairman of the committee.
Speaker, no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment to clause 37? In the absence of any proposed amendment, the question is as many as are in favor of clause 37 standing part of the bill, say aye. Those against say no. The ayes have it. Clause 37 is ordered to stand part of the bill. Clause 38.
Trial.
Chairman of the committee.
Speaker, clause 38, amendment proposed, subclause 4, delete and insert the following as advertised on page 18. I so move, Mr. Speaker.
Honourable members, those in favor of the proposed amendment by the chairman of the committee say aye. Those against say no. The ayes have it. The proposed amendment by the chairman of the committee is ordered to stand part of the bill. Any further amendment to clause 38? In the absence of any further amendment, I'll put a question. Those in favor of clause 38 standing part of the bill say aye. Those against say no. The ayes have it. Clause 38 is ordered to stand part of the bill. Clause 39.
Interlocutory appeals.
Chairman of the committee.
Mr. Speaker, no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment to clause 39? In the absence of any proposed amendment to clause 39, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 39 is ordered to stand part of the bill. Clause 40.
Stay of proceedings.
Chairman of the committee.
Mr. Speaker, no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment to clause 40? In the absence of any proposed amendment, I'll put a question. As many as are in favor say aye. Those against say no. The ayes have it. Clause 40 is ordered to stand part of the bill. Clause 41.
Day-to-day trial of case.
Chairman of the committee may move amendment XVIII.
Mr. Speaker, amendment XVIII, clause 41, proposes subclause 1, line 2 and 3, delete a day-to-day and insert an expeditious. I so move.
Honourable members, the proposed amendment is for the consideration of the House. Any further amendment? I'll put a question to the proposed amendment. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Chairman, you may move amendment XIX.
Mr. Speaker, XIX, subclause 2, line 1, delete a day-to-day and insert an expeditious. And in line 3, delete 14 and insert 7. I so move, Mr. Speaker.
So let's take this. I'll put a question. Those in favor of the proposed amendment say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Chairman, you may move amendment XX.
Amendment proposed XX is to delete the entire clause. I so move, Mr. Speaker.
Honourable members, any further amendment to the amendment proposed by the chairman of the committee? In the absence of any proposed amendment, I'll put a question. As many as are in favor say aye. Those against say no. Honourable members, yes. Honourable Majority Leader.
Yeah, Mr. Speaker, I know you've passed 41 already, but...
We are now on 41.
We're now on 41?
Yes.
Yeah, 41 line...
So let's finish putting the question on this. Before I put a question on entire clause 41, then you can raise your issue. Those in favor of the proposed amendment say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill, and consequently, subclause 3 is deleted. Yes. Majority Leader.
Yeah, Mr. Speaker, if we can go back to where we try to delete day-to-day and then insert an expeditious. If you say shall proceed on an expeditious basis. Proceed on an expeditious basis. I doubt if that is a proper, coherent rendition. Because what it says is that delete day to day and then leave basis, and in place of day to day, you say an expeditious basis. That's not
So
accurate.
the rendition will be a trial commenced under the Minerals and the Mining Act 2006, Act 703, shall proceed on an expeditious basis until the conclusion of the trial, except where an expeditious trial is impracticable.
So the proper rendition should be, shall proceed expeditiously. Shall proceed expeditiously until the conclusion of the trial, except where an expeditious trial is impracticable. That would be a proper rendition.
Very well. Chairman of the committee?
Mr. Speaker, I'm minded to go with
Very well. Then I'll then put a question on the amendment proposed by Yes, leader. According to the drafters, that it will be problematic. So we should leave it the way it is. Yes, Majority Leader.
Yeah, Mr. Speaker, the thinking is that the court should sit daily, because one of the issues that the whole architecture of the tribunal system is meant to deal with is adjournments. The public outcry regarding, adjournments and how that frustrates the administration of justice. So the idea is to put pressure on a panel of the tribunal to sit every single day until they dispose of the matter, except where it is impracticable for them to sit every single day until the matter is disposed of.
So if you put it that way, what happens if the court did not sit on daily basis?
Well, the idea is that the court must sit on a day-to-day basis. That's the idea informing the reform, unless it is impracticable for them to sit, assuming that it rains and the whole area is flooded and their lives are at risk if they try to get to the tribunal, building, or some other circumstance that makes it impracticable, assuming that a member of the panel suddenly falls ill and therefore they cannot, constitute a panel to try the matter. But the principle is to deal with the adjournments that have tended to frustrate the administration of justice by demanding that they sit on a day-to-day basis to hear the matter and dispose of it expeditiously, unless that is not practicable. That's the principle.
Attorney General, what do you say to this?
Right Honorable Speaker, I support the initial rendition because, as the leader has pointed out, the idea is to ensure that the long adjournments are a thing of the past when it comes to the tribunals. And I think that day-to-day or daily is a more precise concept than expeditious. So I support the initial rendition that are brought in the bill.
Chairman of the committee, what do you say?
Mr. Speaker, this we debated for some time.
That's why I was deferring to my committee.
And so on the basis of that, I am now just seeing the deletion of 3 to tie in with getting back to the old rendition or the original rendition, where
I'll prevail on you to abandon your amendment and let's allow what is in the bill to pertain.
Mr. Speaker, except to say that XX, I now want to see the same 41.
Because your amendment will also have impact on the head note.
On which one?
On the head note.
Because the head note says day-to-day trial of cases.
Yeah. So, Mr. Speaker, I will abandon clause 41. I will abandon XVIII and XIX. We will have to debate XX then.
Very well.
After the abandonment of
Very well.
clause 2.
Very well. So, honourable members, Chairman has abandoned the proposed amendment that will put a question on. But in order not to have a problem, I'll put the question on the entire clause 41. Chairman having abandoned the proposed amendment in XVII and XIV. Those in favor of clause 41 as amended standing part of the bill, say aye. Those against, say no. The ayes have it. Clause 41 as amended in XX to delete subclause 3 is ordered to stand part of the bill. Clause 42.
Adoption of proceedings.
Chairman of the committee.
Mr. Speaker, may I get you right on X?
So the only amendment carried here
is XX.
Is XX.
Brilliant. That's fine.
That's what I'm saying. Clause 41, you have abandoned XVII,
yes,
XIX. So the only amendment carried is in XX.
Very well.
That's why I use the word as amended in SX to delete subclause 3.
Noted, Mr. Speaker.
Very well. So we proceed to clause 42.
Adoption of proceedings.
Chairman of the committee.
Mr. Speaker, no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment to clause 42? I'll put a question. Those in favor of clause 42 standing part of the bill, say aye. Those against, say no. Honourable members, the ayes have it. Clause 42 is ordered to stand part of the bill. Clause 43.
Establishment of Tribunal Oversight Committee.
Chairman of the committee.
Mr. Speaker, clause 43, amendment proposed, delete and insert the following as advertised on page 18. I so move.
Honourable members, the proposed amendment is for the consideration of the House. Any further amendment? In the absence of any further amendment, the question is as many as are in favor of the proposed amendment by the chairman of the committee, say aye. Those against, say no. The ayes have it. The proposed amendment to clause 43 is ordered to stand part of the bill. Now I'll put a question on clause 43 as amended. Those in favor say aye. Those against say no. Clause 43 as amended is ordered to stand part of the bill. Clause 44.
Membership of committee.
Chairman of the committee.
Speaker, XXII, clause 44, amendment proposed, subclause 1, paragraph A, delete and insert the following. I so move, Mr. Speaker.
Honourable members, the proposed amendment is for your consideration. Any further amendment? In the absence of any further amendment, I'll put a question. Those in favor of the proposed amendment say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Clause 44.
XXII, Mr. Speaker.
That is so.
Amendment proposed, subclause 1, paragraph B, subparagraph II, line 2, after justice, insert not below the rank of a deputy director. I so move, Mr. Speaker.
Members, I'll put a question. As many as are in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Still on clause 44.
Speaker, rightly so. XXIV, clause 44, amendment proposed, subclause 1, paragraph B, subparagraph III, delete. I so move, Mr. Speaker.
Honourable members, the proposed amendment is for your consideration. Honourable members, in the absence of any further amendment, I'll put a question. Those in favour of the deletion of subclause 1, paragraph B, II, say aye. Those against say no. The ayes have it. Subclause 1, paragraph B, subparagraph II is accordingly ordered to be deleted. Yes, Chairman, still on clause 44.
Rightly so, Mr. Speaker. XXV, clause 44, amendment proposed, subclause 1, after paragraph B, insert the following new paragraph as advertised on page 19. I so move, Mr. Speaker.
Honourable members, the proposed amendment is for your consideration. Any further amendment to the proposed amendment? In the absence of any further amendment, I'll put a question to the proposed amendment. Those in favour say aye. Those against say no. The ayes have it. The proposed amendment to clause 44 is ordered to stand part of the bill. Yes, Chairman, your last amendment to clause 44.
The last one, Mr. Speaker. XVI, clause 44, amendment proposed, sub clause 1, paragraph C, delete and insert the following new clause. 1 chief nominated by the Regional House of Chiefs of the region. I so move.
Honourable members, the proposed amendment is for your consideration. Any further amendment? In the absence of any further amendment, I'll put a question. Those in favour say aye. Those against say no. The ayes have it. The proposed amendment to clause 44 is ordered to stand part of the bill. Now, honourable members, I'll put a question to clause 44 as variously amended in the absence of any further amendment. Yes, Honourable Baba Jamal.
Mr. Speaker, I'm looking at XXV, where the amendment that we adopted is a lawyer with not less than 7 years standing as a lawyer nominated by organizations of lawyers. Mr. Speaker,
Honourable Baba Jamal, we are in a learning curve.
Yes.
At the consideration stage, when a question is put on an amendment, and the amendment is carried, you can only propose a further amendment upon the leave of the Speaker.
Mr. Speaker, that's exactly what I'm trying to do. To seek your leave to reconsider that position.
Very well, you may go ahead.
So, Mr. Speaker, I'm saying that if by organizations of lawyers, if we say organizations of lawyers, what do we mean by organizations of lawyers? Do we say it's organization by an organization of lawyers, so that we are specific on it, by an organization of lawyers? But if you say organizations of lawyers, how does it define it? But if you say, yes, but when you say organizations of lawyers, we have different organizations of lawyers. So, but we are not yet in a situation where we have an umbrella for all organizations of lawyers in Ghana. We don't have that umbrella of organizations in Ghana.
Honourable members, it's a legitimate issue that he's raising, so let's listen to him.
Yes, so because now we have a situation where we have the Ghana GBA, and now we have the Society of Lawyers and other organizations. So if we can say...
Is it the Law Society of Ghana or Society of Lawyers?
Law Society of Ghana.
So pronounce it well. Ghana Bar Association.
Ghana Bar Association and Society of Lawyers. Mr. Speaker, what I'm trying to draw attention is that if we make it this way, if the rendition is this way, standing as a lawyer,
I think we get your point. Chairman of the committee, what do you say to it?
Nominated by...
In other words, Attorney General, what do you say to this? What do you say to the expression that he's indicating?
Mr. Chairman.
So now we have two organizations.
Yes.
Which one will do the nomination?
Mr. Speaker, in legislative drafting, the singular includes the plural. So there's no need to add organizations to it. I think there was some debate within the committee with respect to whether we could use the language or the expression association of lawyers, because of the fact that it might imply that this is a reference to the GBA or the Ghana Bar Association, instead of a reference to a generic reference to the Association of Lawyers in the region. So that is why the committee proposed instead to use organization of lawyers. But I do agree that instead of organizations of lawyers, we should be using one, like an organization of lawyers.
Very well. So you are proposing that we delete the S?
That is so, Mr.
Or
Speaker.
we delete the organizations and then replace it with
Mr.
organizations?
Speaker, you and the chairman, you are both Cavendish-trained legislative drafting
You are
experts.
also part of the Cavendish trained legislative drafters. We went to the school together with you. So the proposal is to delete organizations and insert organization. Yes, Chairman. Chairman.
It's working now. It's working now.
Okay. Mr. Speaker, the intendment is to choose one lawyer, whether there are 10 organizations or not. However, they come together to get a lawyer to represent. And so the reason we use a plural, even though we're mindful of the drafting, the Cavendish training you and I attended, Mr. Speaker. And so Mr. Ward-Brew has an association. I don't know whether it's dead or it's still around. Plus the other one, Mr. Speaker. And there's a newly created association, which we belong, Mr. Speaker. Proudly.
I understand all those things, but the question is that from which association or which association will do the nomination? Because there are two now.
Yes.
If the nominating authority, for instance, is Attorney General, we don't have a problem. We can only say that a lawyer with not less than 7 years standing as a lawyer, nominated by the Attorney General. But this one, you say it should be nominated by a body, and we have two. Which one will do the nomination? That is the issue being raised by Baba Jamal.
Yes.
Baba Jamal, is that not the issue?
Yeah, that's the issue.
Yes.
So it is either, Mr. Speaker, if I propose, it's either we make it an organization of lawyers, or we take that confusion away, because it's likely that there can be even another organization of lawyers.
Yes, if you make it organization of lawyers.
That's right.
Which organization are we going to expect
so we can give it
to
to
do the nomination?
So we can give
So
it to
there
the
is some
Attorney General to
uncertainty
nominate.
there. Yes, Honorable Sosu, let me hear you.
Mr. Speaker, I just wanted to draw your attention to the fact that we don't just have two, because we also have Lawyers in Search of Democracy, which is also an association of lawyers. So I think that to avoid the confusion, we can...
And it's likely we will have lawyers who doesn't belong to any of the associations.
Exactly.
In line with the principle established by the Supreme Court
Association.
In the case of Ward-Brew versus Ghana Bar Association.
Exactly. So I think we can reserve that to the Attorney General, so that we don't get involved into, which association a rep. So you still want a rep from an association.
Yes.
Yeah, so it means you can be in any of the association and be nominated to the yes.
Yes, Chairman of the committee.
Mr. Speaker, the intendment is that we want one person. We want one person, one representative.
Yes, the
The
question, we
association-
agree on the intendment.
Yes.
Now, the issue that we have to address, and we need your help, is that we have so many associations. Maybe tomorrow I'll be forming one. Which of the association will do the nomination?
Mr. Speaker, the intendment is that those associations will come together and nominate. Those
Don't you see a
associations
difficulty there?
will come together
Please,
and
please,
nominate.
please, please. Yes, Honorable James Akarga.
So, Mr. Speaker, in order to cure the mischief ably identified by my brother Baba Jamal, let us further amend the word association to associations and further amend to read as follows. So if you have associations, then they will do the nomination on a rotational basis so that in a given year, if Ghana Law Society is called upon to do the nomination, subsequently, the lot would fall on GBA to nominate. That is the only way to cure the problem, the problem. So let's have association.
Honorable members, with all due respect, the Attorney General at every point is the leader of the bar, whether the Law Society, whether the Ghana Bar, or whether Ahia Force Lawyer Society. The leader at all those places is the Attorney General. So I propose that the rendition should be a lawyer with not less than 7 years standing as a lawyer nominated by the Attorney General. Yes?
Okay. No.
Mr. Speaker, the committee is supposed to represent interest groups. This is the policy underpinning. It is a committee that represents interest groups. The committee is also, I believe, at the regional level. So the idea is that the committee is composed of representatives of the Attorney General, of the Human Rights Commission, and of lawyers practicing in the region. That is the idea. Lawyers practicing in the region. Lawyers in good standing practicing in the region. That's the objective. So you have lawyers, you have the Human Rights Commission, and you have the AG's office. They constitute the oversight committee. The oversight committee is established at the regional level. Yes, the oversight committee is established at the regional level. So in each region, you want the committee to represent the AG, the Human Rights Commission, and then lawyers in good standing practicing in the region. That is what the objective is. So lawyers in good standing practicing in the region will then develop a convention by which they meet to choose their representative. So that it's not done on the basis of associations, but on the basis of lawyers who have registered and are practicing in the region. Yes, they belong to different associations, but we don't want to be enacting associations. We don't want to be enacting associations. In fact, the whole idea is to move away from the enactment of associations. So you don't say Ghana Bar Association. Then you have Progressive Lawyer Association coming to
take you on and challenging and going to court and saying that the legislation is discriminatory because it recognizes one association to the exclusion of another association. So the idea is to have representatives of lawyers in the region. So let's craft it so that the rendition captures the intent that the tribunal is a three-legged entity, one leg representing Human Rights Commission in the region, one leg representing AG's office in the region, and one leg representing lawyers practicing in the region, lawyers of good standing practicing in the region. So let's find a way of crafting it to reflect that.
So your argument is sound, but it appears impracticable. Impracticable in the sense that we agree that the lawyer 7 years standing at the bar should be appointed from the region. But who nominates that person? That is what we are talking about. So if you don't want the Attorney General, let's come out with a proposal that leads to how those lawyers are nominated from the region. Yes, Majority Leader.
See, when you say association or organization of lawyers, how about if in the region they don't have an organization of lawyers? You see, so, but you will have lawyers practicing in the region. And what I believe will happen if we enact that lawyers practicing in the region, a convention will evolve where lawyers who know they practice in the region will convene themselves to nominate somebody. Otherwise, then let's go to the old rendition where there is an association that everybody knows as an association of lawyers, and then say that they should nominate.
Majority Leader, that will be vague. That will be vague. We need to give the power to nominate
Mr. Speaker.
To an entity.
Mr. Speaker.
Yes. Let me hear James Agalga.
So, Mr. Speaker, I can understand when the majority leader says we should not legislate on organizations. But the truth of the matter is that the Constitution itself allows for freedom of association. So that is a right which is already enshrined. And therefore, like it or not, the existence of organizations is something the Constitution already recognizes. And that is why I am saying that the real problem here is which of the associations. Now, we are allowed to have a multiplicity of associations, bar associations. That is why we now have Ghana Law Society, Ghana Bar Association, and World Bruce Association of Lawyers. So, how do you legislate to ensure that none of those associations or organizations enjoys a monopoly when it comes to the question of nominating lawyers for purposes of appointment? And that is why I propose that let us allow the organizations with S, the plural, to stand.
So,
and then,
in that case, for the
Speaker,
purposes of being nominated, you are compelled to belong to an association.
well, Mr. Speaker, in this country, practically, do we have lawyers who don't belong to?
If you read the principle established in the case of World Brew versus Ghana Bar Association, the Supreme Court says the Constitution guarantees freedom of association.
Yes.
So membership is not compulsory. So you can be a lawyer and decide not to belong to any association. Because the Constitution guarantees freedom of association.
Yes.
So if we adopt your rendition, it means that for you to qualify, you must belong to an association.
Mr. Speaker, practically, we have had Ghana Bar Association all this while. Mr. Speaker, most legislations clothe the Bar Association with the power to nominate. Have we ever had a situation whereby somebody who is not a member of the association found it necessary to raise questions about
yes,
the
if you look at the history
of the Bar Association?
If you look at the history of it,
yes,
until recently, the only association is the Ghana Bar Association. And there is a compulsory nature of it until the matter has been taken to the Supreme Court.
Mr.
That's
Speaker,
why
look here small.
so many associations are now coming. So the monopoly is broken. At first, it's as if you can't call yourself a lawyer until you belong to the bar. That is why we normally say, like this one would have said, good standing at the bar.
Mr. Speaker, look here small.
Yes.
Mr. Speaker, because our colleagues have left the chamber, you are minded not to be looking at this place. You don't expect them to be here, but please, I'll urge you to be looking at this side small. Mr. Speaker, you made a proposal.
Well, let me advise you. The rules allow that when we are at the consideration stage, you can move from wherever you are sitting to group.
Okay, so that I can get closer.
But, yes, but apart from the consideration stage of a bill, you must get up on your feet and catch the eye of the speaker to speak.
That's right.
The only dispensation granted by the rules is at the consideration stage of a bill.
Yes.
So normally what happens is you move to an area where people who do advocacy in favor are. So next time I will advise you to do that.
I will take a clue from that. Mr. Speaker, you made a proposal which got very close to resolving this matter. To avoid this confusion about associations and organizations, and taking into consideration the fact that Attorney General itself will be maybe represented on the committee, can we look at it from this aspect? The nomination will come from the Attorney General, all right, but it should be from the private sector. So we can have a private legal practitioner nominated by the Attorney General. So even when Attorney General is represented, you have a private legal practitioner represented, so that we don't run into the problem of these associations. Because as for the associations, once the gate is open, more associations will come in. So I want a rendition, as you know, nominated by that a private legal practitioner nominated by.
No, that in our context, if you are talking about a private legal practitioner, a corporate lawyer in Baba Jamal and Co. Is he also qualified to be a private legal practitioner?
Maybe I will use a different phrase. Instead of the private legal practitioner, maybe we see from the private sector or something. But whatever I'm saying is that it should be a private legal practitioner nominated by the Attorney General. So we avoid this problem of these associations. And so we make it specific. So the Attorney General can nominate any private legal practitioner practicing in the region or in the whatever at any point. So it should be a private legal practitioner, a private lawyer, a lawyer who is not working in government or whatever. It should be a private legal. If we do it that way, we'll get it specific.
Yes, Chairman of the committee.
Mr. Speaker, I think we have flogged this clause for some time now. My suggestion is that once it is a regional oversight committee, we should give that power to nominate to the supervising high court judge in the region. The supervising high court judge in the region to nominate a lawyer a lawyer with not less than 7 years standing. That's it. And so we can leave out the association. So a lawyer may belong to association or not. And so that this excludes lawyers who don't belong to any of these associations.
Yes, the proposal is that we give that function to the judiciary to perform.
For
Yes.
the supervising high court judge in the region.
Chairman of the, yes, majority leader.
Mr. Speaker, we say that there are issues with the traditional court system. We are creating a tribunal. Then we'll go and say that the High Court judge, who is of the same qualification as the chairman of the tribunal, he should appoint somebody to supervise the chairman of the tribunal. How can we do that? How can we do that? How can we say that the High Court judge should appoint somebody? Yes, that's what we're saying. He should nominate a lawyer to serve on the oversight committee that is oversighting the tribunal in the region. And you are saying that the High Court judge, supervising High Court judge in that region, should be the one appointing a lawyer to supervise the tribunal chairman. So we can say the Chief Justice, but not the supervising High Court judge in that region, because he is of the same stature as the tribunal chairman. Their qualifications are the same. So why should he be the one appointing a supervising, committee member?
So, honourable members, do we defer the clause? Because the qualification of the chairman of the tribunal is equivalent to that of the High Court. You are going to appoint a lawyer 7 years to supervise? Yes, to serve on that particular committee. How we owe fidelity to seniority at the bar? Yes, Attorney General.
Mr. Speaker, this is a committee, and the committee can benefit from the wisdom of the legal practitioners, and it doesn't matter that the legal practitioner is 2 years. No, we are saying 7 years, because under Act 32, that is the point at which you are allowed to practice on your own. So a person like that can serve on the committee. And it's an oversight committee that is more or less monitoring and evaluating the work of the tribunals. At the Legal Profession Act. So
yes, it's just like asking Shaibu to evaluate and supervise your work.
Mr. Speaker, pardon me. It's
just like asking Shaibu as a lawyer to evaluate and supervise your work as Attorney General.
Well, no, Mr. Speaker, I think the collective wisdom of the committee is what we are driving at.
Very well.
Not necessarily the individual members of the committee.
Very well.
And remember that we have the Commission on Human Rights and Administrative Justice on it. Okay, and we have a representative from the Judicial Council nominated by the Chief Justice.
So who does the nomination? Yes, let me hear from Honorable Bid Asidi. I want Azuma.
Mr. Speaker, if you look at the membership of the committee, they are nominated by bodies or institutions. So in the case of the Judicial Council, the Chief Justice nominates somebody from that place. The Commission on Human Rights and Administrative Justice, the Commissioner nominates. There is a representative to be nominated by the Regional House of Chiefs or the National House of Chiefs. And also, the Chief Justice will have to nominate 2 persons, at least one of whom is a woman. So the Chief Justice has been given the opportunity to nominate people from the Judicial Council and at the same time from the public. So I don't find anything wrong if we give that authority to the Chief Justice to nominate any lawyer from the region. So then we have solved the problem of having to ask the various associations to come together to nominate. The Chief Justice takes that responsibility and exercises it. And then he just picks a lawyer from the region, and then the lawyer will be part of the oversight committee. So, Mr. Speaker, that is my proposal.
Very well. It's for the consideration of the House. Yes.
Mr. Speaker, when you look at what we are talking here, we are looking for a lawyer who is maybe practicing lawyer. The Attorney General is the leader of the bar. It is a lawyer we are looking for. Attorney General is the leader of the bar. So if Attorney General is the leader of the bar, and we want a lawyer, who will be the best to select somebody to represent? That's why we are, and from the bodies that have been selected, the only people who are not represented is the private lawyers, is those who are practicing. So can't we say that the Attorney General will nominate a private lawyer to represent on the committee, so that the lawyers who practice in the region will have a representative on the committee, nominated by the leader of the bar. So he should nominate. Yeah, the leader of the bar should nominate. So I think that if we do it, now I move that the rendition should be this, Mr. Speaker. I think it should be a private lawyer with not less than 7 years standing. A lawyer with not less than 7 years standing as a lawyer, nominated by the Attorney General. Simple. The Attorney General will look through the lawyers.
Honorable Chairman.
Yes.
Mr. Speaker, I am minded to support this.
I've made this amendment long ago.
Yes.
I'll put a question.
Back to your amendment. AG.
Yes.
Hey, James.
That my colleague Baba Jamal used the word private.
Please,
yes.
please.
Oh, you've taken it out.
Please.
Very well.
He took it out.
I heard it, yes.
No, he took it out. As many as are in favor of the proposed amendment say aye. Those against say no. The ayes have it. The proposed amendment is carried. Now I'll put a question on entire clause 44 as variously amended. Those in favor say aye. Those against say no. The ayes have it. Clause 44 as variously amended is ordered to stand part of the bill. Clause 45.
Functions of the committee.
Chairman of the committee.
Mr. Speaker, no advertised amendments. No advertised amendments.
It is for the consideration of the House. All members, any proposed amendment to clause 45? In the absence of any proposed amendment, I'll put a question. As many as are in favor say aye. Those against say no. The ayes have it. Clause 45 is ordered to stand part of the bill. Clause 46.
Tenure of office of members of the committee.
Chairman of the committee.
Mr. Speaker, I think I jotted something small on 46.
We are not interested in what you jotted. Just tell us the amendment.
Mr. Speaker, 46(5), line 3, after inability, insert of the member.
Very well. I'll put a question. As many as are in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Any further amendment to clause 46? I'll put a question on entire clause 46 as amended. Those in favor say aye. Those against say no. The ayes have it. Clause 46 as amended is ordered to stand part of the bill. Clause 47.
Meetings of the committee.
Chairman of the committee.
Mr. Speaker, no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment to clause 47? In the absence of any proposed amendment, I'll put a question. As many as are in favor say aye. Those against say no. The ayes have it. Clause 47 is ordered to stand part of the bill. Clause 48.
Disclosure of interest.
Chairman of the committee.
Mr. Speaker, no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment? In the absence of any proposed amendment, I'll put a question on clause 48. As many as are in favor say aye.
Aye.
Those against say no. The ayes have it. Clause 48 is ordered to stand part of the bill. Clause 50.
Supervision of tribunals.
Chairman of the committee.
Mr. Speaker, no advertised amendment.
It is for the consideration of the House. Any proposed amendment to clause 50? In the absence of any proposed amendment, I'll put a question. As many as are in favor of clause 50 standing part of the bill say aye. Those against say no. The ayes have it. Clause 50 is ordered to stand part of the bill. Clause 51.
Annual reports.
Chairman of the committee.
Mr. Speaker, clause 51, amendment proposed, subclause 1, line 3, after the insert committee and. I so move, Mr. Speaker.
Honourable members, the proposed amendment is for your consideration. Any further amendment? In the absence of any further amendment, I'll put a question. Those in favor of clause 51, those in favor of clause 51 standing part of the bill say aye. Those against say no. The ayes have it. Clause 51 is ordered to stand. Clause 51 as amended is ordered to stand part of the bill. Clause 52.
Record keeping.
Chairman of the committee.
Mr. Speaker, clause 52, amendment proposed, subclause 1, line 2, delete audio and insert electronic.
The proposed amendment is for the consideration of the House. Any further amendment? In the absence of any proposed amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Now, I'll put a question on entire clause 52. Those in favor say aye. Those against say no. The ayes have it. Clause 52 as amended is ordered to stand part of the bill. Clause 53.
Ethics and integrity.
Chairman of the committee. Chairman, clause 53. Please, who is putting the microphone on?
Mr. Speaker,
Yes.
no advertised amendment.
You are sitting down, you are not even voting, you are complaining of being tired. There is no advertised amendment to clause 53. I will therefore put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 53 is ordered to stand part of the bill. Clause 54.
Immunity of chairman and members of tribunal.
Chairman of the committee.
Mr. Speaker, no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment to clause 54? In the absence of any proposed amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 54 is ordered to stand part of the bill. Clause 55.
Modification of enactment.
Chairman of the committee.
Mr. Speaker, no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment to clause 55? In the absence of any proposed amendment, I'll put a question. Those in favor say aye. Those against say no. Honourable members, the ayes have it. Clause 55 is ordered to stand part of the bill. Clause 66.
Regulations.
Mr. Speaker, 5-6.
Chairman of the committee. No, I said 56.
Clause 5-6.
Yes. 56.
Mr. Speaker, amendment proposed, subclause 1, line 1, delete Chief Justice may and insert Minister shall within 12 months after the coming into force of this act. I so move, Mr. Speaker.
All members, the proposed amendment is for the consideration of the House. Any further amendment? In the absence of any further amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment to clause 56 is ordered to stand part of the bill. Now I'll put a question on the entire clause 56. As many as are in favor say aye. Those against say no. The ayes have it. Clause 56 as amended is ordered to stand part of the bill. Clause 57.
Interpretation.
Chairman of the committee.
Mr. Speaker, amendment proposed after interpretation for Judicial Council, insert the following new definition. Minister means the minister, the Attorney General and Minister for Justice. I so move, Mr. Speaker.
All members, the proposed amendment is for your consideration. Any further amendment? In the absence of any further amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Now I'll put a question on the entire clause 57. In the absence of any further amendment, those in favor say aye. Those against say no. The ayes have it. Clause 57 is ordered to stand part of the bill. Honourable members, clause 58.
Consequential amendment.
Chairman of the committee.
Speaker, no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment? In the absence of any proposed amendment, I'll put a question on clause 58. Those in favor say aye. Those against say no. The ayes have it. Clause 58 is ordered to stand part of the bill. Clause 59.
Savings.
Chairman of the committee.
Mr. Speaker, no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment? I'll put a question. As many as are in favor say aye. Those against say no. Honourable members, clause 59 is ordered to stand part of the bill. The schedule.
Timelines for determination of a case under the Minerals and Mining Act 2006 at 703.
Chairman of the committee.
Mr. Speaker, schedule, proposed amendment, delete. I so move, Mr. Speaker.
So I'll put a question. As many as are in favor of the proposed amendment say aye. Those against say no. All members, the ayes have it. The schedule in the bill is accordingly ordered to be deleted. All members, we come to the long title.
An act to provide for the establishment, jurisdiction, composition, and operation of tribunals in accordance with the Constitution, establish the Tribunal Oversight Committee, and for related matters.
Yes.
Mr. Speaker, may I crave your indulgence and seek your permission to take us back to clause 25.
To
page 17, clause 25.
Very
of the
well,
order
leave
paper.
it.
Of the order paper. Yeah. Mr. Speaker, we propose a new rendition for 25, thus inserting the new sub-clause. We propose that the tribunal shall ensure that an order issued complies with the rules of procedure and guarantees a fair trial. This is a new rendition we want to replace.
So are you deleting and inserting this?
Yes. So we're deleting.
You are making it as an additional clause.
And inserting this. Agree? Yeah.
You see, Honorable Shaibu.
Yes.
As a man, you have to speak for your vocal cord to vibrate. You speak for your vocal cord to vibrate.
Speaker, very well.
So the question therefore is, are you proposing
Yes, I am.
that
we delete
the entire clause 25, as in 1
new,
and 2,
yes,
be deleted?
Yes.
And in place?
In place of it, we have the following rendition.
Yes.
The tribunal shall ensure that an order issued complies with the rules of procedure and guarantees a fair trial. I so move.
AG, what do you say to this amendment?
Mr. Speaker, I agree with the chairman's amendment.
Very well, I'll put a question. Those in favor say aye. Yes. You see, that's why I ask, are you deleting 25 as in 1 and 2? The drafter is saying that 25.1 is staying. It is 25.2 that they are recrafting. Because the 25.1 is cross-referencing the very procedure in the Criminal and Other Offences Act. So what do you say? So your proposed amendment is delete clause 25.2 and replace with a new rendition. Do you want to come as second consideration?
Yeah. So, Mr. Speaker, may I just go over it again?
Leader.
24, the new subclause has two components. We are maintaining the first component. It's the second component that we are deleting and replacing it with the new rendition.
Yes, but that wasn't what you said initially.
Very well.
That was not what I was going to put a question on. So, honourable members, for the record, the proposal is to delete 25.2.
25.2.
And substitute it with a new rendition as read by the chairman. The proposal is to, yes, and we have not taken this amendment. We've taken this amendment. We have taken this amendment. Yes. So it's a session. Yes. So is this what they have for the amendment? So, honourable members, the amendment actually is not to delete clause 25. He said after subclause 1, insert the following new clauses. So it's an insertion after subclause 1, as in page 17. And page 17 is in twofold. 1, the Evidence Act 1975, NRCD 323, applies to the proceedings of the tribunal. 2, An order issued by the tribunal shall ensure compliance with rules of procedure and guarantee a fair trial. So in this case, it is the insertion that you are further amending in 2. Is that it?
So, Mr. Speaker, in 2, we are just deleting the 2 and inserting the new rendition.
Very well.
Yes. So we are taking away an order issued by the tribunal, the whole of the...
Honourable members, the chairman is not speaking loud, and you are also speaking.
Mr. Speaker, the 25 has 2 components, 1 and 2. We are not touching 1. We are replacing 2 with this new rendition. And may I go over it again?
Yes.
The tribunal shall ensure that an order issued complies with the rules of procedure and guarantees a fair trial. I so move, Mr. Speaker.
Very well. Honourable members, the proposal is to further amend.
Yep.
The proposed amendment at page 17 of today's order paper to insert. Yes.
Mr. Speaker, my understanding is that first, he is adding 2 new subclauses.
Yes.
Then, if he does that, subclause 2 now becomes subclause 4.
No, you leave that for the
Yeah,
drafters.
I'm coming. So what he's trying to amend is the existing subclause 2, not replace his amendment. No, the existing subclause 2 is what he seeks to delete and then prefer a new rendition.
Chairman, is that the case? If that is the case, why are you drawing our attention to clause 17? Yes, so leader, there are amendments to clause 25, as in page 17, which amendment has been carried by the House. And this amendment is the insertion after subclause 1. 2 provisions which are inserted, so the numbering will change. Now, what the chairman is seeking to do is to further amend his proposed amendment that has been carried in the second part. Just leave the renumbering for the drafters. So it is not the original 2 that chairman is amending. Chairman, is that the case?
Yes, we are further amending, yes, because it says an order issued by the tribunal shall ensure. It's not the order that shall ensure, but the tribunal, yes. So it is a tribunal that will ensure. That is why we are changing that.
So I'll put a question. Those in favor say aye. Those against say no. Honourable members, the proposed amendment to the chairman's amendment in page 17 of the order paper for today is ordered to stand part of the bill. Honourable members, since it has got to do with clause 25, I must put a question on the entire clause 25 again. Those in favor say aye. Those against say no. The ayes have it. Clause 25, as variously amended, including the further amendment, is ordered to stand part of the bill. Now, the long title has been read. any proposed amendment to the long title? Or it has not been read? Yes.
Mr. Speaker, it's been read.
What is the amendment?
No, the long title has been read.
You said, is there any amendment to the long title?
No proposed amendment, Mr. Speaker.
Honourable members, in the absence of any proposed amendment to the long title, I'll put a question. Those in favor of the long title standing part of the bill say aye. Aye. Those against say no. Honourable members, yes, the Attorney General. Honourable members, the ayes have it. The long title is ordered to stand part of the bill. And honourable members, this brings us to the end of the consideration stage of the Tribunal Bill 2026. Yes, Majority Leader. Any more business?
Mr. Speaker, Mr. Speaker, you've taken the... We are finished with consideration stage.
Yes.
Yes, so Mr. Speaker, we want to take item number 28.
Honourable members, honourable members, let me take 2 minutes of suspension.
So is the order 7
I know. That's what I sent the message to him. Yes, Majority Leader.
No, Mr. Speaker, there are 2 minutes suspension. It's appropriate.
Very well. The House is suspended for 2 minutes.
Mr. Speaker,
Honourable members, welcome back. You may take your seat. Yes, Majority Leader.
Mr. Speaker, we want to take motion advertised on page 20, numbered 28, to abridge time so that we can take the Tribunals Bill 2026 through the 3rd reading.
Motion number 28. The Attorney General and Minister for Justice.
Mr. Speaker, may I move that notwithstanding the provision in Order 172, Sub-Order 1 of the Standing Orders, which requires that when a bill has passed through the consideration stage, the 3rd reading thereof shall not be taken until at least 1 sitting day has elapsed. The motion for the 3rd reading of the Tribunals Bill 2026 may be moved today. I so move, Mr. Speaker.
Honourable members, motion ably moved. Any seconder?
Mr. Speaker, I beg to second the motion.
Honourable members, motion moved and seconded. It is for the consideration of the House. This is a procedural motion. The question, therefore, is as many as are in favor of the motion say aye. Aye. Those against say no. The ayes have it. The motion is carried. Now the consequential motion is 29.
Mr. Speaker, may I
Attorney
move
General and Minister for Justice.
the Tribunals Bill 2026 be now read the third time. I so move, Mr. Speaker.
All members, motion move. Any seconder?
Mr. Speaker, I beg to second the motion.
All members, motion move and seconded. It is for the constitution of the House. I'll put a question. As many as are in favor of the motion number 29 at page 20 of today's order paper say aye. Aye. Those against say no. All members, the motion is accordingly adopted.
An act to provide for the establishment, jurisdiction, composition, and operation of tribunals in accordance with the Constitution, establish the Tribunal Oversight Committee, and for related matters.
Honourable members, the Tribunal Bill 2026 is now duly read for the third time and passed. Yes, Majority Leader.
Mr. Speaker, I want to thank members for their perseverance. We are now officially in Friday. So it means that members sat since yesterday actually doing a 24-hour economy work and have passed a bill that is a major commitment of the National Democratic Congress. We campaigned on this particular proposal that if voted for, if elected into office, we will establish the tribunal system of the administration of justice. This message was overwhelmingly voted for by the people of Ghana. I believe that those who today are questioning our decision to enact this law are in effect questioning the judgment of the several millions of Ghanaians who voted the NDC into office. We as a party will remain true to the commitments that we made to the people. And so let me commend members. We know that Ghanaians want to have confidence in the administration of justice. We believe the setting up of tribunals will go a long way to restore confidence in the administration of justice. Let's give the tribunals an opportunity. Let's shape it and make it deliver expeditious administration of justice, which we believe will engender public confidence in our democracy. So I want to thank the Speaker for persevering. He has been sitting since yesterday and has so ably steered the affairs of this House for us to arrive at this successful passage of the bill. So, Mr. Speaker, I want to thank you for your effort, your endurance, your perseverance, your tolerance. You have tolerated a lot to get us to this stage, and we want to commend you for your tolerance. Colleagues, I cannot say any more how pleased I am with your actions since yesterday. Some of our colleagues were in the voter regime and did whatever it took to arrive back in the chamber to be able to enable us constitute the quorum. Others were actually in bed when we called, and they had to leave and come and join us. Come and join us to pass this bill. As for the table office, they have been sitting in the chamber since 2 p.m. yesterday, and we have to commend them, led by the clerk, who has provided invaluable guidance throughout the passage of this bill. I believe that all the concerns that civil society groups have been adequately dealt with, and I urge civil society groups to take a look at the bill and the various provisions of the bill, and if there are concerns, I believe that this house is a listening house and we can revisit some of the issues that they are concerned about. But for now, we believe that we have provided Ghana with the best framework for a tribunal system of administrative justice as one can possibly have. Lastly, let me commend and thank our journalists, our media, our press corps. They have been with us since yesterday, and I believe that we need, as a house, to commend them for being with us through thick and thin as we worked towards the passage of this bill. Mr. Speaker, I want to urge colleagues, when driving home, please drive carefully. I believe that we are all very tired and might be sleepy, and so drive carefully back home. Mr. Speaker, the Attorney General says that during the day, we'll all smile. Thank you very much, Mr. Speaker.
Honourable members, clearly we have sat from 12 o'clock on the 16th July 2026 to 12 o'clock 17th July 2026. Definitely we have done more than 5 hours. In the circumstances, I have the authority to adjourn the House based on Standing Order 56-2. I therefore adjourn the House till Friday, 17 July 2026 at 12 noon. In other words, I adjourn the House to today, 17th July 2026 at 12 noon. Thank you very much, honorable members, for your patience.
The say yes,